Thank you. Good morning, everyone, and welcome to the Assembly Committee on Judiciary. I'm going to call this meeting to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola. Assemblyman Miller.
I'm here.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. I believe everyone is present. That means we do have a quorum. Good morning to committee members. Good morning to the numerous guests who are joining us on the Zoom this morning. And good morning to those who may be watching either on the internet or the legislature's YouTube channel. Welcome to day 59 of the 81st session of the Nevada Legislature. Before we get started with today's agenda, I just want to go over some quick housekeeping matters. We have a lot of guests with us on the Zoom, and so I'd ask you if you could please mute yourself when you're not speaking. That'll help with the audio feedback. And then if you are presenting or answering questions today, if you could remember to state your name each time before you speak, that will really help our committee secretaries prepare accurate minutes of the meeting. We do expect courtesy and respect in our interactions with one another. Sometimes we disagree on policy. That today's bill might show some of those disagreements. That is perfectly okay, but we need to make sure that we're being respectful of one another, of the legislative institution, and most importantly, of our very hardworking staff. And then finally, many members are using multiple devices to access this virtual meeting, including extra desktops, laptops, monitors, iPads, iPhones. So please don't see it as a sign of disrespect if members appear to be looking away during the meeting. They're most likely accessing notes or exhibits or looking at the bills online. So with those housekeeping matters behind us, committee members, you'll see that we only have one bill on the agenda today. Because I will be helping to present that bill, I will hand the virtual gavel over to Vice Chair Nguyen, and I will now take the virtual presentation table.
Thank you. I will open the hearing on Assembly Bill 395. It abolishes capital punishment. We have a pretty tight schedule here, and I want to make sure that I ensure fairness and we allow every support, opposition, and the presentation, as well as questions from committee members to go through in an efficient and fair way. So I do have some pretty strong stop times. I know all of the presenters are aware of that. I don't have a problem cutting off Chair Yeager if he starts to go over that time, and I know that he is prepared for that as well. Again, I want to make sure that we are able to get to as many callers as we need to from the public, as well as have an ample opportunity for our members to ask questions. So with that, it is 8:06, and we will begin our presentation. And when we have about 5 minutes left of the presentation, I will give you a kind of a heads up, Chair Yeager, so your presenters can wrap up as well. And with that, I will turn it over to you.
Good morning, Madam Vice Chair, members of the Assembly Judiciary Committee. For the record, I am Steve Yeager, representing Assembly District 9, which is located in Southwest Las Vegas. Today, I humbly present Assembly Bill 395 for your consideration. Assembly Bill 395 is not a complex bill. It eliminates the death penalty in Nevada and converts all existing death sentences to life without the possibility of parole, meaning those offenders will die in prison. Because in Nevada, life in prison means just that, life in prison. This morning's hearing is not going to be an easy one. Many people have deeply personal feelings about the death penalty. I certainly do. I'm opposed to the death penalty for a number of reasons, many of which you will hear during the presentation of this bill. But the question for this committee and for the legislature as a whole is not a personal decision, but rather it's a policy decision. The question is whether Nevada ought to keep the death penalty on its books beyond this legislative session. Even if you are fairly firm in your belief that we ought to have the death penalty, I ask you to listen to the testimony today and to keep an open mind. Once I conclude, you're going to hear brief testimony from 10 other presenters. That testimony will make the case for abolishing the death penalty. The testimony will demonstrate that the death penalty is both very costly and ineffective as a deterrent. You're going to hear that innocent and wrongfully convicted persons have been sentenced to death. You're going to hear about the lengthy litigation involved in the death penalty that can involve further trauma for the family members of victims without any real closure, since the state is unable to put anybody to death. You're going to hear the perspective of family members of the condemned. You're going to hear about the racial bias of the death penalty. You're going to hear faith-based opposition to the death penalty. Perhaps this testimony will cause you to reconsider your position on the death penalty. That being said, this is going to be an emotional and difficult hearing. You may be brought to tears by some of the testimony, and I'm here to tell you that that is okay. There is simply too much unnecessary pain in the world. People are capable of inflicting and do inflict immense pain and suffering on their fellow human beings. To feel that pain in today's hearing is what makes you human. It is what makes you empathetic. I hope we never lose the ability to feel empathy and share in another's pain. But even in the midst of sharing in that pain, we need to come together as Nevadans to evaluate whether the death penalty is working and whether it should remain as part of Nevada's justice system. China, Iran, Saudi Arabia, Egypt, Pakistan, Yemen, Somalia, South Sudan. These are among the dwindling number of countries that still have the death penalty. Although I would like to see the US remove itself from that list, that's a decision for our federal elected officials. The decision for us is whether Nevada should follow Virginia's lead and rid itself of the death penalty. I believe we should. Madam Chair, I would now like to hand it over to Mr. Tom Valoria to make some additional remarks.
Go ahead, Mr. Valoria. And please state your name for the record before you speak.
Yes, good morning. My name is Tom Valoria, Madam Chair, committee members, and those in attendance. The beginning point is I'm a former prosecutor in Northern Nevada and was a member of the original Major Violators Unit, responsible at that time for the high-profile cases, death penalty cases, and homicide cases in general. From 1992 till 1998, in May, when I left the office, my primary function was to handle all of the murder cases, as well as I did all of the capital litigation. I was also the representative of the office of the GACL, which is the Association of Government Attorneys Involved in Capital Litigation, highly trained and specialized group of prosecutors across the nation whose focus is death penalty litigation. At that time, when I left, I had placed more people on any other prosecutor in the North on death row. I was in support of the death penalty, obviously believed in it, and it was my mission as part of my responsibility to seek justice in the appropriate cases when aggravating circumstances were present to seek it if appropriate. I want to talk a little bit about the process, and I am here today in support of AB 395, asking that Nevada take action and abolish the death penalty. And I'll briefly hit those moments. As I understand, I have 3 minutes and then I've got to leave. I'm in the middle of trial. The process of selecting those cases for the death penalty is inherently flawed. And when I say that, I can only speak to what happened during my time frame up north. I can't speak to what happens in the South. But I could tell you that what would occur would be a staffing of the facts of that particular case among those prosecutors with the most experience in murder cases, and generally the DA or sometimes the assistant DA would sit in those meetings. Those meetings would generally only last somewhere between an hour to 2 hours. And the prosecutor who was assigned the case was charged with presenting the facts, the aggravating, and arguing if they elected to seek the death penalty, why the case was death penalty appropriate. The problem lies in not every person in that room had read the entirety of the file. Typically, the only person who had read the file front to back was the assigned prosecutor. So in the end of the day, you have really the motivation and desire and will of that singly assigned prosecutor who is making the ultimate call to seek the death penalty. If that prosecutor wants to hard sell the facts and the aggravators and minimize those things that are important mitigators that should be taken into account, that prosecutor can do so. There's no check and balance on that individual prosecutor's decision. Now, we can all say, well, everybody discusses it and there's a staffing and it's a conclusion. I understand that. But in the end of the day, if you as the assigned prosecutor in the North wanted to seek and obtain the death penalty, you could present your case in the light most favorable in that staffing so that you could get the green light to seek it. That is problematic in many ways. There are, and of course, unfortunately, I had experience firsthand, seeking some prosecutors who their agendas, their personal motives, and their reasoning for seeking the death penalty had very little to seeking justice. They had other reasons, whether it be advancement, prestige, notoriety, or just the general reputation of being a hard-nosed bulldog prosecutor as they advanced through their career. So the process of it in and of itself for the selection and when you are going to seek the death penalty is arbitrary. And in fact, there's no guidelines on that process. There's no rules on the process. That's solely at the discretion of each individual DA's office. The next thing I want to address is the time and resources involved in these cases is tremendous. I prosecuted the serial killer up here, Mr. Dave Middleton, for example. That case, my investigator and I personally interviewed over 350 potential witnesses. I called over 100 witnesses in case in chief, called over 19 experts in that matter, and obtained 2 death sentences as a result of the 2 homicides here that the serial killer, Mr. Middleton, did. That case took me out of practice of any other cases for a substantial period of time. Not to mention the costs associated with that case. I think the final bill on the defense side cost the county upwards of $750,000 just the trial fee alone for the defense lawyers. At that time, I was directed to file a motion to challenge those fees, and I felt that it was inappropriate and it was a violation of the 6th Amendment, so I didn't file that motion. But that's the kind of commitment at the trial level. And of course, we all know the resources that it takes on appeal and the never-ending appellate and post-conviction process. Just too much resource for too little result. The reality is most of these offenders are going to die in prison, not by way of the death penalty, but they're going to go through the process both at the state and federal level of review and appeal. And most of the guys that I put on death row, and they're all males, will probably outlive me. None of them have been executed. The last death warrant I believe that I did was in 1997. And I don't think that any of them are scheduled to die anytime soon. So in the end, it's the same result as life without. They die in prison, and it's more appropriate. It's simply wrong thinking. And I know when you're a prosecutor, you believe you're doing the right thing and your heart and soul is in it and you believe in it. But in my view, it's a little bit of unenlightenment. A simple analogy is this. If a defendant commits the crime of battery with a deadly weapon, do we then take that defendant and beat him with a deadly weapon as punishment? Or if a defendant commits the crime of sexual assault, do we then sodomize and rape that defendant? Well, the idea that retribution is an appropriate punishment, eye for an eye, death for death, is barbaric. It makes no sense both morally, ethically, and legally. It's flat wrong thinking. Lastly, this notion that there's closure is an illusory promise to victims. There is no closure on a capital case. In fact, it's worse. The victims are re-victimized every single time there's some appellate move on behalf of the defendant, or there's some post-conviction move, well, whether it be at state or federal level, that these cases do not come to closure. And the reality is there would be much more closure for these victims if they could have peace of mind knowing that this individual is life without, and life without means that they will die in prison and the victims can move on. The reality is, last time I checked, and I could be wrong, but I believe it was 2006 since anyone's been executed in Nevada. And generally the only time people are executed here is if they volunteer, if they want it. It's not effective, it's too costly, and it's an illusion on behalf of victims. With that said, I thank you, and I would urge this committee and the legislature to support and pass AB 395. Thank you. I won't be available for questions unless someone had them now. I don't know if that's proper. Like I said, I do have to leave. I've got a 9 o'clock trial start. Thank you.
Thank you for your time. Unfortunately, we do have to get to the next presenter. Chair Yeager, who do you have next to present?
Mr. Scott Coffey, please.
Mr. Coffey, please state your name for the record and begin your testimony.
Good morning, Madam Vice Chair. My name is Scott Coffey. I am an attorney with the Clark County Public Defender's Office. I have been there for 25 years. For the past 20 years, I've been on a specialty homicide unit that handles capital cases. It is one of 3 such designated offices in Clark County because of the specialized nature of the death penalty. The others are the Special Public Defender's Office. It was created specifically to handle capital cases, to have 250 qualified attorneys, which is a specialized training and requires some experience, and the Office of Appointed Counsel. I had the privilege of testifying before this committee in 2017, and at that point, I said that, in my opinion, the death penalty was broken. It was broken beyond repair. Nothing's happened in the intervening 4 years to change my mind about that. I want to walk you through the numbers. As a result of my position, I've tracked numbers in Clark County and across the state for the past 20 years. So I've got some idea of what I'm talking about when I say the system is broken. Currently, right now, we have 62 pending capital cases, including reverse penalty phases, in Clark County. That is the highest per capita in the country by my estimate, and there are more than 3,000 counties in the United States. So we are number 1 out of 3,000. In terms of absolute terms, we're probably I know we're in the top 5, we're probably top 1 or 2. Those 62 cases cost $500,000 more than a typical murder case, according to the LCB. Those are their numbers. Some people might disagree with the numbers, but I think those numbers are fairly accurate. Historically, over the last 10 years, if we look at what's happened in Clark County, let's talk about what we get bang for the buck. We've had 150 capital cases that have resolved since January 1st of 2010. Of those, 100 have pled. We've had another dozen that were dismissed by motion or dismissal of some sort, and 36 have went to trial. Of the 36 that went to trial, we've had 16 capital verdicts. 5 of those have already been overturned, and they aren't very far in the appellate process. But 5 have been overturned, which means with the LCB numbers, we've spent $75 million to put 11 people on death row. Now, from there, the numbers get even worse. Once we get to death row in Nevada, since the mid-'70s, we've had 161 people sentenced to death row. We've had 12 executions. 11 of those people have volunteered. The one non-volunteer was a man named Richard Moran, who represented himself, pled guilty, and had some severe questions that went all the way to the United States Supreme Court concerning his competency. The point is, we don't execute anybody even when a death sentence is imposed. But the money's spent. If you look at the LCB numbers, over the last 10 years, we've spent $75 million to place those 11 men on the row, and they're more likely to die of natural causes or suicide than they are to be executed, even if they volunteer. You can take a look at cases like Scott Dozier that made the media recently to see how broken the system is. We can't execute people even when they're asking for it, and that's problematic. If we go even further and look a little further right now, we don't have the means to execute people. We don't have any drugs on hand. We haven't had an execution since the mid-'70s. Recently, Clark County had a case in the media with some fairly horrendous facts. And I suspect the district attorney's office or the district attorneys that are testifying may say that that is an indication that we have to have the death penalty. But the fact is, I think these cases that are in the media are an indication of the failure of the death penalty. The only reason these cases are in the news after 20 years is because the death penalty is on the table, but we still don't have much of an opportunity to execute any of these people. 40 years ago, Nevada reinstated the death penalty a little bit more, and we've not done anything to fix it. Justice Kennedy once said, "I'll tinker no more with the machinery of death." The reason that he said that is because the system can't be fixed. We tried to fix it with the AEDPA with the AEDPA in the federal system to speed up appeals. That has not happened. It's foolish to think that we can fix it going forward. For these reasons, I urge you to pass AB 395, and I will be available for questions at the end of the presentation. I'm sorry for speaking so quickly, but we are on a shot clock.
Thank you, Mr. Coffey, and thank you for being available for questions. Chair Yeager, who is your next presenter?
Miss Nancy Lemke, please.
And I will also let you know you are at the halfway mark. Go ahead, Ms. Lemke.
Sorry, I had to get myself unmuted. Good morning, and thank you all for allowing me the opportunity to present at this very important hearing. As many of you know, my name is Nancy Lemke. I am a lawyer in Las Vegas, Nevada, and a proud 25-year veteran of the Clark County Public Defender's Office. For those of you who are not aware, 25 years ago, I represented a man by the name of Fred Stees. Fred was wrongfully convicted of first-degree murder, and as a result, he was sentenced to life in prison. He languished there for about 20 years before he was able to secure his release and obtain a full pardon. What I think many people don't know about Fred's case is that it was originally prosecuted as a capital murder case, that during the case, while the prosecutors were withholding evidence that exculpated him, they were also in the process of asking a jury to kill him. Mercifully, after he was convicted, we were able to negotiate his sentence to life without the possibility of parole. So he was able to actually live long enough to obtain the relief to which he was so very much entitled, and ultimately walk out of the Nevada Department of Prisons. What I would tell the members of this committee is that what I've learned in 25 years of doing criminal defense work is that while we have certainly the best justice system in the world, it is far from infallible. It is comprised of humans, and humans make mistakes, they make poor decisions, they make errors in judgments, and that includes everybody involved, beginning with law enforcement, moving on to prosecutors, defense attorneys, juries, and judges. And that despite our best efforts, our system remains imperfect. And to the extent that that remains a truism, having a death penalty is certainly, in some ways, kind of a dangerous proposition for people in Fred's place who go through the system and fail to obtain the outcome that they should have had, and that should have been the appropriate result after a jury trial.
Thank you, Ms. Lemke. It's always nice to see you as well. I hope retired life is treating you well. Chair Yeager, if we can go to our next caller.
Thank you. It'll be Miss Cynthia Portaro, please.
Sorry about that. It took me a second. Hi, my name is Cynthia Portaro. My son was brutally shot and killed. "10 years ago today." So needless to say, Assemblyman Yeager, yeah, it's pretty emotional. And whether my son's killer, Brandon J. Hill, is in jail for life or on death penalty, as you said, there is no closure. It doesn't matter. We victims of crime are the ones that are sentenced to a life in prison. That's my opinion. And my opinion is just my opinion. People that are seeking the death penalty, victims of crime, sometimes I do understand the emotional trauma that is imposed on a victim. And when you spend the millions and millions and millions of dollars on this person that's in prison, my thoughts are, why aren't we assisting victims more than giving them $1,000 is what we were compensated for counseling. And counseling takes a little bit more than $1,000 to help somebody to walk through such a difficult journey of their loved one being traumatically killed, brutally murdered in several different ways. So, and as far as life in prison and you die in prison, to me, that's just as much a death penalty as a death penalty. And I know that it cost a lot less money, and this isn't just about cost. This was for my family. This was also a faith decision that we didn't want another young life taken. And, you know, yeah, age isn't a factor when it comes to somebody, you know, brutally killing somebody, but he's a young man that had, you know, maybe something else that he might do positive in prison for others, to talk to others about, you know, what he did and how resentful we felt, and that maybe he was sorry for what he did, because, you know, he did reach out to me and thanked me for forgiving him. Now, have I released that? Has there been closure? No, there is no closure. And I could just, you know, it's not about money. It's about honoring my son, which after, you know, the last 10 years have not been the same. You know, my family was, you know, half my family's gone now that died, you know, and I always think it was because of this act of violence. And, you know, my son was a former football star at Faith Lutheran, graduated, you know, was a good kid. He didn't deserve this. And I don't think anybody else deserves to die because of an act of stupidity. So I don't know what else I can say other than I would like to see, you know, future victims help, you know, that are assisted financially, maybe a little differently, maybe, you know, that we could compensate that the families that maybe lose their breadwinner, or, you know, families like me that have other children that need counseling. And the other thing I just wanted to point out was, in honoring my son, I have helped numerous families get through the tragic loss of a loved one, you know, mainly young kids, whether it be however they passed away. And so for me, that's a way to honor my child. And so thank you for allowing me to speak. Thank you that, you know, this process of the death penalty, I think, just draws on families that have to sit through parole, chance of parole or postponements and all that. And it's just, I think it's just too much on a family to have to handle. Thank you.
Thank you, Ms. Portoro. Sorry. I'm sorry for your loss. And on this anniversary of his death, I'm sure I'm speaking for all the committee members. Our hearts are with you. Chair Yeager, do you have any other people presenting?
There are still a few others. The next one would be Miss Heather Lynn Snedeker.
Hi. Okay. My name is Heather Snedeker. I live in Las Vegas. And 22 years ago, my dad was executed by the state of Texas. I was 8 years old when my dad was sentenced to death. Before then, I didn't even know he existed. Imagine, if you can, this scene from the eyes of an 8-year-old girl with no familiarity of the state. I was in a cage with dozens of armed guards surrounding me. They didn't smile at me. One led me to a chair that was sitting across from a plexiglass divider with telephones on both ends of the glass. The guard told me I would have 30 minutes to talk to my dad. Surrounded by very serious men with guns, I was expecting to see a vicious monster in front of me, someone who was almost animalistic. After all, it's easier to imagine incarcerated people as animals because that justification leads us to locking them in cages. But I didn't see a monster across from me. I saw a man, a human being, my dad. I saw the same blue eyes staring back at me that I saw every time I looked in the mirror. I saw a concerned dad who wanted to make sure his daughter knew all the important life lessons he should teach her, but only had 30 minutes to do it. I asked the parents in the committee here today, if you were told you only had half an hour left in your life to talk to your children, what would you say? He said anything he could think of at the time. Stay in school, get a graduate degree, respect your mom, respect yourself. Don't act on impulse, and don't do drugs, especially the kind he used when he took another man's life. When the 30 minutes was over, I looked over at my dad, who was crying. I wanted to hug him so bad, to let him know that it was okay, that I forgave him for abandoning me now, when we finally got to have our daddy-daughter moment. I asked the armed guard escorting me if I could give my dad a hug just once in my life before we parted for good. He said no. Tearfully, my dad was led away, not knowing what else to say other than, "Be good, kiddo." A few weeks later, my dad was killed by the state of Texas by lethal injection. From the window where witnesses could watch, my grandma held up my stuffed Tweety Bird toy from when I was a baby against the glass. It was the last thing my dad saw as he died. I wonder if at that moment he thought of more fatherly advice he wished he could have told me before he was killed. We'll never know. I'm here today to show you all that when you execute someone, you're not punishing them. You're punishing the families, the children like me who are left to suffer and pick up the pieces of our shattered lives. No one from the state reached out to me to see how the execution would affect me or paid for the years and years of intense therapy that followed. The only communication I ever received from the state was a letter from then Governor George W. Bush denying my plea to stop my dad's execution, adding that my dad was going to burn in hell. If any of you are shocked that the future president of the United States spoke that way to a little girl, don't be. That's the message sent from a system that exterminates the human beings that you deem unworthy of redemption. Thank you.
Thank you. Chair Yeager, can we go to our next presenter?
Yes, please, Mr. Randy Fiedler.
Thank you, Honorable Chair, Vice Chair, and the members of the Assembly Judiciary Committee. My name is Randy Fiedler, and I am here on behalf of Nevada Attorneys for Criminal Justice. I am a criminal defense lawyer who represents Nevada death row inmates in their state and federal post-conviction proceedings. I will briefly discuss the reversal rate in death penalty cases and the appellate process. Our current process was created in the 1977 statute that was passed in response to a problem identified by the U.S. Supreme Court, namely that death sentences in this country were being imposed arbitrarily or because of race. The court declared the death penalty unconstitutional until states could craft better, more reliable statutes in recognition of the fact that death is different. Nevada answered this call in 1977, passing a statute specifically intended to end racism and arbitrariness in application of its death penalty. To that end, there are a number of procedural protections, including a robust system of review. After conviction, appeals would happen automatically. And after the appeal, attorneys would be appointed for post-conviction proceedings. And then, after state review, these convictions would be reviewed in federal court, where, too, Congress has tried to improve the efficiency and reliability of review with the Anti-Terrorism and Effective Death Penalty Act, commonly referred to as the AEDPA. All of this in recognition of the fact that death is different. But even with these efforts, we have a reversal rate of more than 50%. Our death sentences have been reversed nearly 100 times in a state that has only had one involuntary execution. If you receive a death sentence in Nevada and do not waive your appeals, you are 100 times more likely to have your sentence reversed than to have it executed. This undercuts any of the rationales for the death penalty. A sentence with such a low chance of execution cannot deter. These reversals suggest we are not giving the sentence for the most severe offenses, and this reversal rate, which injects incredible unpredictability into the appellate process, is unhelpful to victim survivors, as a 2012 study found in comparing victim outcomes in a death penalty state and a non-death penalty state. This reversal rate must be considered within its historical context. This is the fixed statute. This body in 1977 felt that they had crafted a statute that would ensure reliability, but it's been almost 45 years, and that reliability remains elusive. Death is too different, and this practice should be discontinued. Thank you.
Thank you, Mr. Fiedler. If we can go to our next presenter.
Be Dr. Tyler Perry, please.
Thank you to this legislative body for allowing me to testify. My name is Tyler D. Perry, and I'm an assistant professor of African American and African Diaspora Studies at the University of Nevada, Las Vegas. The commentaries on the death penalty discuss the issue from many angles, be they economic, political, or practical. Each piece of this broader puzzle is important, but I'll take a moment to provide a different reason for eliminating the death penalty option, one that is grounded in the country's history of anti-Black racism and Nevada's own culpability in perpetuating inequality against its most marginalized populations. Any honest assessment of the death penalty statistics should cause alarm for the disparities it exposes. Investigative journalism by the Marshall Project revealed that a large share of those who face the death penalty experience mental illness, childhood abuse, and brain injuries at some point prior to their crime. The experience of trauma and the lack of resources to support underrepresented and marginalized people seeking recovery and rehabilitation is one of the invisible, if always omnipresent, reasons for committing violent crime. The statistics are relevant here. According to the Death Penalty Information Center, among those executed, and I'll quote, more than 1/3 had suffered a brain injury or had an intellectual disability, while nearly 2 in 5 were diagnosed with a severe mental illness, and almost 2/3 experienced extensive trauma as children, unquote. By abolishing the death penalty, we have the opportunity to make a decisive shift as a state and community from one that fatally punishes those that the system already failed to one that emphasizes proactive community development and offers services to those seeking state assistance. Most in this legislature will know the state's well-deserved nickname, Mississippi of the West, due to the combination of Jim Crow-style segregation that disenfranchised Black Las Vegans and heavy-handed policing from the late 1980s up to 2015. Systemic racism throughout Nevada has led to the disproportionate representation of African Americans in Nevada's carceral system, be they imprisoned, in jail, on probation, or parole. All of this relates to the embedded anti-Blackness of capital punishment, and the state's death row statistics clearly expose the problem. In Nevada, 37% of death row inmates are Black, though African Americans represent 9% of the population. On a national level, it is not coincidental that as lynchings waned in the United States in the mid-20th century, capital punishment rose in prominence and disproportionately impacted Black men. The connection was so obvious to many African Americans that these formalized executions were nicknamed legal lynchings, in which they detected that America's vigilante forms of anti-Black violence were replaced with state-approved killings of Black people. Institutions like the Equal Justice Initiative connect the death penalty's history to anti-Black racism, citing racial bias both inside and outside the courtroom, the arbitrary nature of sentencing, inadequate counsel representing the accused, and the prevalence of institutional racism and community divestment in the areas where many of the accused come of age, expose how capital punishment actually amplifies systemic racism and does nothing to solve it. In fact, it leads many to distrust the system even more. To conclude, I hope the Nevada legislature makes the correct decision to abolish the death penalty and establish a precedent for reforming other systems that further disenfranchise and marginalize vulnerable populations. As one born and raised in Las Vegas and will watch his oldest daughter enter the Clark County School District next academic year, the same district I graduated from nearly 20 years ago, I hope her future history courses note that in 2021, Nevada's elected representatives made the correct decision in abolishing the practice forever. Thank you.
Thank you, Dr. Perry. I think next we are going to Justice Cherry.
Can you hear me?
We can hear you, Justice Cherry. Go ahead.
Well, folks, thank you for this privilege to appear before the Assembly Judiciary Committee. I've been a lawyer and a judge for 51 years. I was here in 1970 when they had the death penalty. Then in 1976, it was reinstated. I can tell you that it's not an equal penalty. The death penalty is not equal in this state because rurals can't afford to have death penalty cases. Washoe once in a while has a death penalty case, and unfortunately, we have plenty of death penalty cases in Clark County. I represented a man in 1980. In fact, they had to move the venue to Douglas County because it was such a high-profile case, and he's been on death row for 41 years. That's longer than some of you are alive. I had another fella who I represented when I was the special public defender, and he's been on death row for 23 years, and he's a stroke victim. So I don't know what's going to happen to him. I don't know if the state would ever kill a stroke victim. To me, that's inhumane. I want you to know that they asked me to talk about death is different, and I think death is different in the rurals, death is different in Washoe, and death is different in Clark County, and that's because of the financial impact that it has on these counties. I want you to know that life without the possibility of parole in this state is life without the possibility of parole. As a defense attorney and a judge, I agree that there are some people that just cannot be in society, and that's why we have life without the possibility of parole. But we certainly don't need a death penalty in this state. Being here for 51 years, it's time you take action. This is not to be put off. I was so impressed with all the speakers so far, especially the young lady whose father was executed, and the lady whose son was killed. This shows you the whole value of death penalty has gone away. It doesn't make sense. Not all the states have it. The federal government at the end of the Trump administration did do some executions after many years. Let's be progressive. 37% of the death penalty people are African American. That doesn't make any sense when there's systematic racism in this country. So I ask you, please, let's do it. I've been here for 51 years. I've got a man on death row for 41 years, another one for 23 years, and it's time to just take action. God bless all of you. Please stay safe and take action. Don't put this off this year. 2021 should be the year that Nevada got rid of the death penalty. Thank you very much for allowing me to share these views with you. And I'm sharing not as a justice and even not as an attorney, but just as a human being. Thank you very much. God bless all of you.
Thank you, Justice Cherry. Next up, I think we have Chair Yeager. Who do we have next?
Thank you. We just have two more. We have Father Chuck and then Miss Nancy Hart. I see Father Chuck is there. Hopefully he can, there we go. I think his camera's turning on, and if you can provide your testimony, please.
Thank you. I was having trouble earlier, so we had to disconnect from the host, so we got back on. Thank you very much, everyone. I'm Father Chuck Durante. I'm a lifelong resident of Nevada and currently rector at St. Thomas Aquinas Cathedral in Reno, Vicar General of the Diocese of Reno, and I chair our Life, Peace, and Justice Commission. And first, I want to say thank you for taking the time, for allowing me to testify, but taking the time to look at this critical bill to end the use of the death penalty in our great state of Nevada. I have prayed and labored in opposition of the death penalty for the past 25 years. I have ministered in our prisons and prayed for the end of the death penalty and rallied outside prisons and the nights of executions. I also have met with family members of murder victims. And over the years and through these experiences, I am more convinced than ever that allowing the death penalty is immoral, is bad public policy, and dehumanizes our society. Like many state and national governments that have changed their stance on capital punishment over the past 100 years, teaching of the Catholic Church has evolved as well. The Church has clarified that the death penalty is an attack on the inviolability and dignity of the human person, and that while in times past it may have been seen as self-defense, justifiable for the protection of others, this is no longer the case. And to use it as a pretense of protection is wrong and a misuse of power today. It also can permanently remove the possibility of remorse or redemption, as Ms. Snedeker noted about in her father's case as well. You've heard testimony on the blatant unfairness in the application of the death penalty upon the poor, upon people of color. Those factual inequities themselves are sufficient, I think, to set aside just for lack of equal protection. But the violation of human rights becomes even more apparent when we also consider human error and the subjectivity and the fact that many sentenced to death were later found to be innocent. In Nevada, 3 have been so released. The death penalty presumes perfection on the part of the criminal justice system. And even if that possibility could be achieved, the sanctity and dignity of human life is still lost. Ending the death penalty is not diminishing a tough stance on against violence, against crime, or taking away the absolute condemnation of murderous acts. On the contrary, it is taking and teaching a higher road, that we don't turn to killing to show that killing is wrong. The same way we don't beat or torture or rape a person who has done those horrific acts, as we heard earlier, Mr. Valoria referenced as well. It dehumanizes us, and it cannot be purified on a gurney. Please end this tool of death for the good of our state and pass AB 395. Thank you again.
Thank you, Father Durante. Do we have, I think, our final presenter, Chair Yeager, is that correct?
Yes, Miss Nancy Hart, please.
Good morning, committee members. I'm Nancy Hart, president of the Nevada Coalition Against the Death Penalty, here in strong support of AB 395. The Coalition Against the Death Penalty is a constantly growing group of individuals and organizations opposed to capital punishment for a multitude of reasons. We are in a budget crisis, but we believe that now is the time to end the death penalty in Nevada. We are in a budget crisis, and the death penalty is enormously expensive while delivering no result. The definition of government waste. We haven't had an execution in 15 years. In fact, we could not carry out an execution 2 years ago due to the drug companies prohibiting the use of their medications in lethal injection. Any effort to conduct an execution now will no doubt result in considerable litigation regarding the lethal drugs, and I refer you to the exhibits for a paper about this issue. The rate of reversals in death cases illustrates how very broken the death penalty system is. Reversals are not only costly and inevitable, they cause victim family members to relive the trauma of the loss of their loved ones to terrible violence. Death penalty cases involve decades of litigation, depriving victims' family members of the legal finality they deserve and could get with life without parole. 2020 was a year in which most people in this country gained a new awareness and fresh concern about issues of longstanding racial injustice, especially in the criminal legal system. The death penalty is at the pinnacle of these concerns, as Dr. Perry's testimony illuminated. Ending the death penalty now recognizes that it's past time to correct this unfair and discriminatory practice. Public opinion has shifted in the past few years. A majority of Nevadans now prefer alternatives to the death penalty. Only 36% support retaining it, and this tracks parallel trends in national public opinion. You will see several exhibits illustrating this shift to support for abolition, including recent statewide poll results and a sign-on letter with 58 organizations and community leaders in Nevada supporting this legislation. I appreciate the opportunity to convey the coalition's support for this important legislation. This is the right time to end Nevada's costly, ineffective, unfair, and inhumane death penalty. Thank you.
Chair Yeager, do you have any further remarks, or would you like to move to questions?
Steve Yeager for the record. Just want to thank you, Vice Chair, members of the committee, for letting us go. I know we went a little bit longer than expected, but we would be ready for questions and would just ask, we'll try to pick one person to answer the question so we can get through as many as possible.
Thank you. I would definitely appreciate that. And just for the record, we are at 45 minutes final time for the presentation of this bill. Again, I would echo Chair Yeager's sentiment to the speakers and allow one person to answer so we don't have a round robin of people answering every single question from our members. And with that, I will start with Assemblywoman Cohen.
Thank you, Vice Chair, and thank you all for the presentation, especially those of you who have personal experience with this. So my question is for one of the defense attorneys, and I'm not sure who would want to answer it, but Mr. Floria had testified about arbitrariness in determining who death would be sought on their case, and that there was, there could be an attempt to improve a career, there could be a lack of proper vetting. What do you, as a defense attorney, have as a tool against that to deal with those types of situations in defending your clients?
Scott Coffey, I've been designated to field questions. Madam Vice Chair and Assemblywoman Cohen.
Feel free to go directly to the member asking the question, Mr. Coffey.
Thank you. So what do we have to combat against it?
And I'm sorry, state your name before you speak.
I'm sorry, yes. I apologize. Scott Coffey. What we have to combat against that is not much, to be quite honest. What we've got, I suppose, long-term is the appellate process, which is part of the reason we see these cases taking 20, 30 years, even more. We've had people on death row since the 70s that are still there. I think most of the prosecutors try to do a good job, but I can't imagine the conversation with a murder victim's family telling them that their loved one is not worth the death penalty if the death penalty's out there. And so I think the motivations get tangled as much as would try to be objective. And I think it's very difficult to combat that. The truth of the matter is these cases are in the media and people like the notoriety, the defendants, and sometimes the attorneys. And it's problematic.
Thank you. And may I ask a second question, Vice Chair?
Go ahead, Assemblywoman Cohen.
Thank you. This is for Ms. Hart. You mentioned that the coalition has been growing. Can you give us numbers, like how many members between the coalition and all the member groups of the coalition are we talking about, and how has the numbers shifted in Nevada? I know you've said that they have shifted and that we're seeing more people who are against the death penalty, but can you give us can you quantify that?
Assemblywoman Cohen, yes.
Ms. Hart, can you state your name for the record, please?
Oh, I'm sorry. Yes, Nancy Hart with the Coalition Against the Death Penalty. Assemblywoman Cohen, the shift in support is revealed through a number of different things. I hear you asking about numbers within the coalition. It's and also with membership of the groups that are part of the coalition. I frankly can't answer that question because we have members from organizational members from churches and from the Life, Peace, and Justice Commission and from organizations that have whole memberships, and I'm not familiar with the membership numbers within those. I know that we have thousands of followers on Facebook and Twitter, and we also have several hundred individuals that have signed the petition that is in the exhibits. We have close to 1,000 people on our email list. And those are just some numbers that represent some of, and those numbers are considerably greater than they were 4 years ago when we were having this hearing. It's on a similar bill. I don't know if that answers your question.
Okay, yes, thank you.
Thank you. If we can go next to Assemblyman Wheeler.
Thank you, Madam Vice Chair. I appreciate it. I think this question may be for the chairman. Actually, anyone could answer it. I'm a little confused here. A lot has been made here about the process itself and how long it takes before a death penalty is carried out, et cetera. And what I've seen, what I've read, a lot of it shows, you go through the appeal process, which is probably a very good thing because you don't want an innocent person being put to death. And then also there's a lot of court cases, Mr. Chairman, and usually those involve cruel and unusual punishment. And from what I've seen and what's happened here in Nevada, I think the drug companies, a lot of them have pulled their drugs off and asked us not to use them for death penalty cases because they're afraid of lawsuits as well. So what I'm wondering, I know that we have a bill in another committee going on, I think right now, that would allow terminally ill people, to use this drug cocktail to take their own lives. So I'm wondering why that's not cruel and unusual, yet using it on a convicted person is cruel and unusual. And that time period, even the people that plead guilty, say they did it, and ask for the death penalty, say they want it. Why can't we use that? It's the process here that I'm wondering about, sir.
Steve Yeager, for the record. I don't want to try to answer that because I may get it wrong, but I think either Mr. Coffey or Mr. Fiedler might be able to handle that from an Eighth Amendment cruel and unusual perspective.
Okay, thank you, Mr. Chairman.
Assemblyman Wheeler, Scott Coffey, for the record. So there had been a lot of Eighth Amendment litigation. There was a case called Glossip that came down from the United States Supreme Court about 5 years ago, which removed a lot of the cruel and unusual litigation regarding the drug cocktails. They essentially said that some pain is expected in the death penalty, and there was no guarantee, even in the Eighth Amendment, that it need not be painless. But there's ongoing litigation about other things, usually the effective assistance of counsel, that not enough has been going on with the defense. The defense didn't do an adequate job investigating, even though National Judicial Council says we spent 1,800 hours as defense attorneys on average on a capital case, as opposed to about 400 on a non-capital case. That is usually where the attack is now. And Mr. Fiedler's very familiar with that, but a lot of that happens in federal court.
Thank you, Mr. Coffey. I don't think that really question, but maybe I can have a discussion with one of my colleagues offline and we can move this along.
Mr. Fiedler, do you think you might be able to address some of those issues?
Yes. So I think it's important to distinguish what the pharmaceutical
Can I have you state your name for the record?
I apologize. Randy Fiedler for the record. I think we need to distinguish what the courts are doing with these challenges and what the pharmaceutical companies are doing. I think the pharmaceutical companies are, they might be worried about lawsuits, but I think they're also worried about the public portrayal of their drugs being used as instruments of death and execution. And so in a lot of cases, these are related to publicity concerns. I'm not familiar with the other bill in the other committee, so I can't speak on that. But I think what Mr. Coffey said about legal challenges to the protocols is accurate. And these challenges in death penalty cases are not just Eighth Amendment challenges to the lethal injection protocols. They are also challenges to the effective assistance of counsel. They're challenges to prosecutorial misconduct that happens during these cases. And so it's not just the one legal issue. It's kind of a system of legal issues that are causing this high reversal rate.
Okay, thank you. Like I said, I'll take it offline with.
And Assemblyman Wheeler, you might want to reach out to various of the pharmaceutical companies, because I think it is a private business. They are choosing not to want to have their drugs administered in that way. So you might want to reach out to pharma.
Actually, I will, but I'll go have a beer with the chairman and we'll talk it out. How about that?
The next question that we have online is Assemblyman O'Neill.
Thank you, Chair. Madam Vice Chair, I appreciate the time. Mr. Coffey, I think that you may answer this question, Mr. Fiedler. Both of you have mentioned that life without means just that, life without the possibility of getting out of prison. It's my understanding, though, that that may not be the case. Actually, that there can be appeals made, arguments made, asking for life without to be commuted to life with, and then processing, going before the parole board and getting released on parole for life. So is that truthful, that life without, truthfully, there is no reprieve from that?
Scott Coffey, for the record. Assemblyman O'Neill, in 1995, there was a constitutional amendment that changed the commutation process and took life without parole off the commutation eligibility. People would still have appeals available. God forbid we put an innocent person in prison on a life without sentence and we find somebody else on video doing the crime. So you have to have some kind of checks and balances. But a sentence of life without is much less likely to be overturned than a death sentence. And it is life without, my understanding, anything post 1995 is life without and cannot be commuted in Nevada.
Thank you.
Assemblyman O'Neill, do you have any follow-up?
No, I appreciate that. Thank you.
Next, we have Assemblywoman Bilberry Axelrod.
Thank you, Madam Vice Chair, and thank everyone who testified today. And, you know, especially, I know we've said that before, but for those of you who were impacted by this personally, thank you for being here and thank you for your courage. My question is about the appellate process and the procedures. The year mentioned was 1977 that we put those appellate processes in place, I believe. If you could just sort of walk me through that, like what does that look like and how long of a time frame and what, if you could just kind of walk me through the process, I would appreciate that. Maybe Mr. Fiedler.
Thank you, Assemblywoman. Randy Fiedler for the record. Yes, and I will start by saying there are a number of intersecting interests that are at play in these cases with regard to state and federal rights. So initially you have your trial, assuming you receive a death sentence at that point, you have an automatic appeal under Nevada law. Assuming you lose that appeal, you then have the right to file a state post-conviction petition for which you are entitled to have counsel appointed. So you have a counseled state post-conviction proceeding in front of the trial court. If you lose that, then you go up to appeal automatically, or not automatically, you go up to appeal to the Nevada Supreme Court. Assuming you lose it at that point, you then have the right to file a post-conviction petition in federal court. In federal court, you are also entitled to have an attorney appointed. The attorneys will then investigate your case. Often new claims will be raised in that federal petition, which will require, to respect states' rights, that the petition be filed in state court so that the state courts have an opportunity to address these claims before the federal courts will address them. So then you file another state post-conviction petition. If you do not succeed in the trial court, you then have the right to take an appeal to the Nevada Supreme Court. If you are not successful at the Nevada Supreme Court, you then go back to federal court where the U.S. District Court will consider your claims. And if you are not successful at that point, you are entitled to take an appeal to the Ninth Circuit. And if you're not successful there, you can ask the U.S. Supreme Court to appeal. At any point in these proceedings, your sentence can be reversed and you can be given a new trial. And that's where we're seeing a lot of these reversals. We're seeing these reversals happening at any point in the direct appeal, state post-conviction, or federal post-conviction proceedings.
Thank you for that.
Do you have any follow-up, Assemblywoman Bilberry Axelrod?
I don't have a question. I'm just kind of shocked at the length and at the process. And I know that's exactly where it needs to be. And I think that, I guess that's it. Thank you.
Thank you. I do have kind of a question on that. I think this might be for Mr. Coffey. Can you describe how the difference between the representation, I mean, you had mentioned that on average, a capital case, 1,800 hours is spent on that, as opposed to a non-capital murder case where 400 hours is spent on that. Can you also describe the difference in representation, like how many attorneys are required to be on a death penalty case as opposed to a murder case? Some of those added like costs that go into those hours. And if it is not handled by one of our public defender offices, how there is a different monetary rate for compensation for those type of cases as well?
Yes, Vice Chair. Just real briefly. So capital.
Oh, can I get you to state your name again?
Oh, sorry about that. Scott Coffey, answering the Vice Chair's question. So capital cases are treated differently under Supreme Court Rule 250, which sets out certain requirements, as opposed to a typical case where you have to have a single attorney appointed. There have to be 2 attorneys that are appointed in a capital case. One of those attorneys has to be capital qualified. That means they have 5 felony jury trials through verdict and have sat through at least a penalty phase with someone else. And they have 5 years experience. Those cases, the reason the cases take so much longer and cost so much more revolves primarily around what's called mitigation. If I am defending a murder case, the murder case, I might investigate 20 minutes or a day in someone's life, perhaps a week. If I'm defending a capital case, I have to investigate their entire history, because if I don't, the case will be turned around either by the Nevada Supreme Court or by the federal court, as Mr. Fiedler described. And that means interviewing grandparents. It means interviewing parents. It means looking into drug history. It means doing IQ testing. It means doing fetal alcohol syndrome testing, which is quite expensive. That alone can cost $40,000 or $50,000 or more without testimony at trial. And those are things that are specific to capital cases. We don't do those in other cases typically. The reason they are specific to capital cases is because cases have been reversed when things are not done. One example that I've got is the Ninth Circuit reversed a case because the attorneys did not look into groundwater poisoning in the village where a defendant grew up. So you have to be meticulous in a capital case, and that takes a lot of time and it takes specialized training. Typically, that would have been done by the public defender's office, but we had so many of these cases and so many conflicts. There was a special public defender's office created about 30 years ago, 25 years ago, that handled the overrun. And we split those cases about evenly until the Office of Appointed Counsel was created in Clark County. That was about 12 or 13 years ago. At one point, there was an even split of those cases, about 30%. But the Office of Appointed Counsel now handles about 60% of the capital cases. They've got about 40 of the 62 that are pending, which is a huge amount because those attorneys are paid hourly, and it is outside the normal budgeting process. It's not part of the public defender's budget. It's not part of the special public defender's budget, district attorney's budget. It is paid out of a special budget hourly at a higher rate than we would normally pay. If we pay $100 an hour normally, I think it's $125 or $150 an hour. So we pay at a higher rate. The bills are generally open billing, and I shouldn't say that. I hate to say there's a blank checkbook, but for capital cases, to some extent, that's the case, because if it's not done right the first time, it gets reversed, and then we just start all over. So that's a short overview of why they cost so much more and why it takes so much more time.
Mr. Coffey, I think Assemblyman O'Neill has a follow-up question based on that answer. So Assemblyman O'Neill, go ahead with your question.
Thank you, Vice Chair, for allowing me to ask one more question. Mr. Coffey, what I hear in your testimony then is that defense will treat a life without case a little less seriously, less time consuming, less preparation, less workup than a capital case. I find that hard to believe, but that's what I hear you saying, that the capital case is so expensive, a life without would be cheaper, and so we should judge it that way. Is that true?
That's absolutely true. And it's not a little less serious, it's a lot less serious. And the courts treat the cases a lot less serious. If I file a brief with the Nevada Supreme Court that's a capital case, it has to be designated as such, and I'm given twice the time to argue the case that I would in a non-capital case. If the case is in federal court, those filings are designated as a capital case. And even all the way to the United States Supreme Court, if I file a petition of cert that has got to be designated as a capital case on the front page of the brief, because as Justice Kennedy said years ago, death is different. Mitigation is not generally a consideration in non-capital cases, and mitigation is what takes time. It's investigating the background. There are certain things that just don't apply in non-capital cases. Atkins, for example, which is IQ testing. If a person's intellectually disabled, they can't be executed under U.S. Supreme Court law, so we spend a lot of money testing for that. That's not the situation in a life without case. You can't make an Atkins claim in a life without case because it's just not an issue. So yeah, the background investigation is vastly different in a non-capital case than a capital case. The defense hours are vastly different. It was the National Judicial Council that came up with the numbers nationwide of 1,800 hours versus 400 or so. So I think there's a general recognition that the cases are just treated differently, as Justice Kennedy said.
Madam Vice Chair, may I be allowed to follow up, please?
Yes, go ahead.
So, Mr. Coffey, if we took capital cases off the table, we did away with capital punishment, you're saying that the life without, which would then become the most serious penalty we could, that we really wouldn't treat them with the same respect. When you're dealing with a human that's looking at life without the possibility of parole, as you said, that we would actually, the court judicial system would say, basically, that's not as important.
Yes, at least under the current standards, that is correct. And not Scott Coffey to Assemblyman O'Neill. And it's not just me that says that. When you look at the cost studies across the board, the states that have got life without parole are handling these sentences all the time. States like Connecticut, states like Massachusetts, a variety of these states. The costs just aren't the same in those states. So unless those attorneys are all incompetent, I don't see where this sea change would come if we simply convert to life without parole. It hasn't happened anyplace else. And I don't think there's any evidence that it would.
I appreciate the answer, Mr. Coffey. Thank you for the time. Thank you, Madam Vice Chair, for allowing me the second question.
No problem. I do have a question regarding that. You're not saying that these attorneys are ineffective and they are not advocating for their clients on simple murder as opposed to death penalty cases. Is that correct, Mr. Coffey?
Absolutely. I'm not saying that they're ineffective. I'm saying that they're just different. Death is different. It has been since it was reinstated in 1977, and it continues to be.
Thank you. And I have 5 minutes left that I've allocated. Like I said, there will be some additional time for questions after opposition testimony. So at this time, I will go to Assemblywoman Summers Armstrong.
Thank you, Chair Wynn, Vice Chair Wynn, Chair Yeager, and all those on the panel, and my condolences and the courage that it took to be here for the families impacted is beyond belief, and I'm grateful that you took the time. My question is for Professor Perry. Professor Justice Cherry made a statement during his presentation, and that is that the rural counties don't have the money to prosecute life cases, and but that Clark County does. And we see, and I'm just curious, what does this mean when we talk about racial disparity and about equity? If you could please speak to that.
Sure. Thank you so much to Tyler D. Perry answering Assemblywoman Summer Armstrong's question. I was actually interested by Judge Cherry's statement in that regard. And for me, it seems that all of this is embedded within a system that views Blackness automatically as criminality. And so it seems no coincidence to me that in a largely urban area in Southern Nevada, populated more heavily by African-American population, probably does have the money to prosecute in this type of format. And much of this goes back to the methods under which resources are allocated. And one thing that makes the United States in general unique within what is called the developed world, but even if you check the statistics of Nevada itself and its incarceration rates, it's actually above the average of the United States, which, as being the country that incarcerates the most people in the world, a disproportionate share of them being of African descent, it is suggestive that Nevada's priorities have largely been retributive against individuals convicted of violent crime rather than utilizing prohibitive measures, things that might be more proactive in trying to help people who are dealing with trauma. And one thing I said in my comments that I think is directly related to these types of questions regarding resources is that it doesn't have to be this way. The US is actually somewhat abnormal within this regard, in that this country is so used to violence that it almost is numbing to some degree within the broader society. I think people are now starting to wake up to this reality and understand that, you know, other countries might even have similar populations, but they are not nearly as violent. And this includes both crime within various neighborhoods, but also police departments and the heavy-handed forms of policing that are all too familiar to Clark County in general. And so my appeal here, or what I typically argue in this regard, is that if we have the resources to invest so heavily in a system of carcerality that does very little to actually rehabilitate people, we can redirect a lot of resources for preventative measures, investing in communities that have been historically divested from, helping people recover from trauma that they experienced as children. And as one of the testimonials alluded to earlier, even the victims of violent crime, the families, receive very little in regards to monetary assistance for therapy. And so the argument here is that our priorities are completely mixed at this present moment, but we have the opportunity to change that. And I think that the abolition of the death penalty can be a step forward to leading to other reforms that I think will benefit a more progressive society.
Thank you so much, Professor Perry. Madam Chair, may I direct a similar question to Mr. Coffey?
Yes, go ahead.
Thank you, Madam. Attorney Coffey, if what Justice Cherry is saying is correct, and I believe I've known of him for many years, does this mean that a person in the rules, who we can assume in most instances because of our population would be white, can do the same crime as someone in Southern Nevada, who we will, for sake of argument, say is Black, that they would see a different sentence or a different charge against them, to be a different charge in a similar, if not almost exact charge?
Scott Coffey answering Assemblywoman Summer Armstrong's question. I think that's exactly what it means. If you look at the demographics by county, once we get out into the rurals, the population of color dwindles tremendously, and most of those people are not going to be subject to the death penalty in the rurals because they simply can't afford it. You would bankrupt a county trying to defend a capital case. It's more than their entire defense budget. If you look at death penalty across the state right now, there are one, two, or three cases pending in the rest of the state and 62 pending in Clark County. So where you commit a crime is as important as the crime that you commit. And by demographic breakdown, that insulates certain members of our population, the white members of our population, from the death penalty being pursued in many instances because the rules just aren't pursuing that. I hope that answers the question.
Thank you, Mr. Cherry. Thank you, Madam Vice Chair.
And I will take the last question here, and this may be for Chair Yeager or Ms. Hart. I did see the financial audit that was there, or it could be from someone from Clark County, since it seems like 60 of the pending death penalty cases are there. Have they had any financial or fiscal note on what cost savings they would be able to save if we were to pass Assembly Bill 395?
Thank you, Madam Vice Chair. Steve Yeager for the record. I'll just say quickly that, I want to recognize Senator, then Assemblyman Orenshaw. That was his bill in 2013. I think it was AB 444 that led to the cost audit of the death penalty. But I probably would hand this over to Mr. Coffey, who I think was actually involved in providing information for that audit. He might have some numbers he could give us.
Thank you, Chairman Yeager. Scott Coffey, just very briefly, the cost audit was provided by the LCB. It actually went through 2 legislative sessions. I was involved in both and involved with Mr. Orenshaw in drafting the cost audit. The first time it didn't go through because there were complaints that it didn't consider things like housing costs and potential savings by executing somebody early. So we corrected those things to try to make it as neutral as we could. The district attorney's offices across the state chose not to participate even after those corrections. But the LCB came to the conclusion that it's about $500,000 every time a death penalty case is filed. Not when death is executed, not when somebody's sentenced to death row, not even when a trial happens. Just simply filing a death notice adds up close to $500,000 in additional cost. So if you look at it that way, you're looking about a $30 million savings, give or take, systemically on the 62 pending cases.
Thank you. And with that, I will stop questions at this time. Like I said, there will be another opportunity to ask questions after receiving the support and opposition and neutral testimony. I will note that I did allow for 30 minutes of questioning by committee members on the original presentation of the bill. At this time, I will begin testimony in support of Assembly Bill 395. I will say that I have allocated 40 minutes of testimony in support, as well as 40 minutes for testimony in opposition. I do have people on the Zoom. I'm going to limit to the people that haven't already been a part of the presentation. I believe we have 4 or 5 people on the Zoom. And again, I will remind them that their testimony is limited to 2 minutes, as well as on the phone. And so with that, we will begin testimony at 9:25, testimony in support of Assembly Bill 395. And if we could go to the Zoom, and I would remind speakers to please clearly state and spell your name for the record. And like I said, I will be timing you. Believe me, it pains me to cut people off, but I will. Take care, and let's start. I think we have Ms. Wellborn, if we could start with her.
Good morning, Vice Chair Wynn, members of the committee. My name is Holly Wellborn, Policy Director for the ACLU of Nevada, testifying in unwavering support of AB 395. The United States is the only advanced Western democracy today that does not view capital punishment as a profound human rights violation and a frightening abuse of government power. Since our founding over 100 years ago, the ACLU has made death penalty abolition a cornerstone of our work. The death penalty is so inconsistent with the underlying values of our democratic system, the pursuit of life, liberty, and happiness, that the imposition of the death penalty for any crime is a denial of civil liberties. This is a deeply broken system that cannot be fixed, and opposition to the death penalty is rising. Nearly half of the states in this country have abolished the death penalty, including Virginia, which at one time had the highest execution rate in the United States. And hearts and minds are shifting here in Nevada. 53% of Nevadans support a penalty other than capital punishment for first-degree murder. And when you explain the exorbitant costs, the fact that innocent people were sent to death row, including Haim Mutin Sharif, who was released from prison in 2017, right after a legislative session when this body chose not to repeal the death penalty, that it offers families a false promise of justice, and that it disproportionately impacts Black, brown, poor, and mentally ill people, the number rises to 58%. I leave you with a quote from an amicus brief filed by the ACLU in Furman versus Georgia. The death penalty is unnecessary in a society with adequate alternative means of fulfilling the legitimate objective of the penal law. The necessarily associated experience of death row shocks and devastates the consciences of civilized men. It is well past time that we repeal the death penalty in Nevada, and we encourage your support.
Thank you. Next up, we can go to Drew Johnson. And again, please state your name for the record before you speak, and your 2 minutes begins now.
Hey, good morning. My name is Drew Johnson. I live in the 9th District. I'm a senior scholar at the National Center for Public Policy Research and a senior fellow at the Taxpayers Protection Alliance. I'm a columnist at Newsmax and the Daily Caller. In other words, I'm not a Democrat. I'm one of a large and growing number of people who identify as Republicans, libertarians, and fiscal and social conservatives who've come to realize the death penalty contradicts the limited government values we hold dear. We also understand that it's really, really bad public policy. In fact, I research the effectiveness of public policy for a living. I look at whether the laws on the books are effective. Do they work? Are they successful? In 20 years of studying public policy, Nevada's death penalty is the single most flawed, least effective law I've ever seen. It's strange that some Republicans will, on one hand, argue that the state isn't capable of handing out a driver's license or counting ballots, but on the other, argue that that same government should have the authority to put people to death. Not surprisingly, giving bloated, inefficient, and often incompetent state governments the authority to decide who lives and dies doesn't always work out very well. More than 160 Americans have been released from death row due to wrongful convictions. Others haven't been so lucky. Putting just one innocent person to death makes the death penalty completely unacceptable. According to estimates by the National Academy of Sciences, states have killed at least 60 innocent people, 60, since America began reinstituting the death penalty in 1976. The death penalty, as Scott Coffey mentioned, is also a tremendous waste of money. In addition to being ridiculously expensive, the death penalty fails at its most basic function, deterring crimes. In 2012, a study by the National Research Council proved once and for all that capital punishment does not reduce or deter crimes. It's also worth noting that states without the death penalty actually have lower murder rates and violent crimes than states with the death penalty. Ultimately, though, it doesn't really matter if you think that people should be put to death in Nevada for committing heinous crimes. It doesn't really matter what state lawmakers want or prosecutors want or victims' families want. That's because between the necessary pills and the difficulty in obtaining lethal injection drugs and Eighth Amendment challenges, the death penalty really doesn't exist in Nevada. Only one person has ever been put to death against his will. All the rest have been volunteers who would rather commit suicide using the death penalty than live out their days in jail, which is a strong indication that life in prison without the possibility of parole.
Mr. Johnson, can I get you to wrap up your testimony?
Sure. The death penalty doesn't deter crimes, it's racist, and it wastes millions of dollars. So why is it still on the book? Many of you Republicans running for office said you wanted to eliminate bad laws and remove policies that aren't effective. Here's your chance. As a Republican, I encourage you to support AB 395. You'll take a completely ineffective law off the books, eliminate felling unnecessary policy, and dramatically reduce the cost to taxpayers. Thank you.
Thank you, Mr. Johnson. If we can go next to Don Gallimore. Maybe not.
Hi there, everyone. I'm Don Gallimore, the Legislative Committee NAACP Renal Sparks Chair, and that's the subcommittee of the Political Action. Elvira Diaz is the chair there. But it's good to be back in a tie for once after a long, long time. But I'm here with the Renal Sparks NAACP to categorically support AB 395. This is a bill that the NAACP has been fighting for 80 years or more. We know that this bill can correct. It's the tip of the rocket ship, if you will. If we can get the elimination of the death penalty, then the lives of up to 3 times to 4 times the number of others as African Americans that will change. That will be down to 0. So what we would like to do is just make sure that everyone knows that we are against any kind of capital punishment, because it is a reflection of slavery and the legal lynching that the professor mentioned, something that is very difficult for parents to teach their children, for us as adults to understand why the hate towards a culture simply because of the color of our skin is the reason for a higher rate of people being put to death, incarcerated in general, and jobless, homeless, things like that. So we want to support AB 395, and in terms of African Americans, we are the original culture in the world. We are the soul of the
Mr.
earth.
Gallimore, can I get you to wrap up your testimony?
I'm done. But thank you very much, Chair Yeager and Assemblyman Cohen.
Next we can go to Monique Norman.
Good morning. My name is Monique Norman. Oh, can you hear me? Okay. Good morning. My name is Monique Norman, and I'm a licensed social worker here in Reno, Nevada. I'm representing myself in support of this bill this morning. In June of 2017, my uncle was stabbed to death in his home in Las Vegas, Nevada. The woman who murdered him stole his car, which was actually my father's car, and left him alone to die in his home. I remember the hurt and the devastation I felt after getting the news of my uncle's murder. I was only 2 weeks away from graduating with my master's degree in college, and honestly, I didn't know what to do. As my family and I sorted through our grief, one of the things I remember my father saying was that he didn't want to see this person get the death penalty, and I had to agree with him. Honestly, it wasn't going to bring my uncle back to us. It wasn't going to heal our pain. And honestly, it brought about more anxiety thinking about it and having to go through that and being connected with someone else's death. Later, we learned during the trial that the woman had suffered much abuse for many years of her life, and she had been trafficked at a very young age. I know that this doesn't change, anything that she did, and it doesn't justify the murder. But as a social worker and as someone who is currently working in the mental health field, I do believe, or I have to believe, that if she had received the mental health care she needed, her life probably would have changed, turned out very differently. Also to note, 1/4 of the people on our death row currently are diagnosed with mental health issues. I asked you today to support AB 395. As a victim, I don't want to see someone else die. And we should also be putting our money into mental health care and prevention and not into executing people. Thank you for your time.
Thank you, Ms. Norman. I do have one more person listed on here. I don't see them. I have Leslie Turner signed in. Is she on here? Chair Yeager, do you know if she is on here? If you are, Ms. Turner, please go ahead and unmute and begin your testimony.
This is Steve Yeager. I don't think she's on. Perhaps she's on the phone. I think that's everyone who's on the Zoom, though, so probably type to go to the phone. Thank you, Madam Vice Chair.
No problem. I just wanted to make sure we got everyone on the Zoom. There's so many people on the screen right now. Broadcast services, if we can begin testimony on the phone in support of Assembly Bill 395.
Good morning. Thank you, Madam Vice Chair. For callers wishing to testify in support, please press *9 now to take your place in the queue. And we will begin with caller with the last 3 digits of 611. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Madam Vice Chair and members of the committee. This is John Pirro from the Clark County Public Defender's Office. Of course, we want people who have harmed another person to be held accountable. However, the question we need to ask is not whether a person deserves to die, but rather, do we as a society deserve to kill them? To get reconciliation, we must be willing to tell the truth. The truth is that the authority to execute someone who is no longer an immediate threat is an awesome power, and that power must be exercised fairly, reliably, and humanely, and we are not able to accomplish this no matter how hard we've tried. The truth is, our use of the death penalty has not been a deterrent. Nevada is 9th in the nation for people on death row, and we have over 60 cases still pending in Clark County to be heard alone. The truth is, the death penalty has not been a deterrent in Nevada. The truth is that for every 9 people executed, 1 person has been exonerated, and that is a shocking rate of error. If 1 out of every 10 planes crash, would any of us still fly? I would not, because of that rate of error. And with that rate of error that we currently have, some of us in Southern Nevada would not live through this whole session. The truth is, Nevada is no different. DeMarlo Berry, who you all met last session, Fred Steese, who we've all heard about, Kirsten Lobato, Kathy Woods, all of them have been exonerated in Nevada after prosecutors sought their conviction and in some cases sought their death. The truth is that wrongful convictions happen in 54% of all exonerations, and over half of the people wrongfully convicted were convicted by wrongful conduct. Fred Steese, prosecutors hid evidence. Kathy Woods, law enforcement coerced a false confession from a mentally ill woman. The truth is that darkness cannot drive out darkness. Only light can do that. Hate cannot drive out hate. Only love can do that. Hate multiplies hate. Violence multiplies violence. And toughness multiplies toughness in a descending spiral of destruction. We are all in need of unmerited grace. So let's please stop this spiral of destruction that is the death penalty in Nevada now. Thank you.
Thank you, Mr. Pirro. We can go to our next testimony in support of Assembly Bill 396.
Next caller with the last three digits of 037. Caller, please state and spell your name for the record. You have 2 minutes and may begin.
Tanya Brown, TONJABROWM, advocate for the inmates and the innocent. Good morning, Vice Chair Wynn and the members of the Assembly Judiciary. We strongly support AB 395. I'd like to say over the years, there has been presentations submitted and to the ACAJ and legislative hearings on the death penalty. And I recall that the figure is around $1 million to prosecute, from going from prosecution to executing a person. Now, I want to touch on something on behalf of the innocent. In 2017, the legislature passed the AB 268 bill, which was the DNA bill to allow DNA testing. Originally, the bill was to allow DNA testing at the inmate's own expense if the court had denied them DNA testing. I'm bringing this up because of what Mr. Valori had mentioned about the David Middleton case, and with the passing of the public records request bill. Some cases have come up recently, and one of those is the Middleton case. I am not saying that Middleton is innocent by no means. What I am saying is that there is another individual, I'll just name him Mr. G. Mr. G and Mr. Middleton were tried 4 months apart. Mr. G has always maintained his innocence. And it would be several years later, Mr. G would receive a document to get DNA testing. And it happened to be in the Middleton case. Middleton was suspected of murdering Mr. G's victim. In 2017, Mr. G filed a petition to allow DNA testing to be conducted, to have that testing conducted. He was denied DNA testing, and if it did come back, it would show that Mr. Middleton not only committed 2 murders, but an additional murder. In 1979, another
Ms. Brown, can you please wrap up your testimony? And if you have any additional, you know that you can always submit it in writing.
Yes, thank you. I will. I just want to say that in 1979, a 19-year-old was convicted of murder. He received the death penalty. He actually did not participate in the actual murder, but he was present. He received the death penalty. And then in 1989, the Supreme Court...
Sorry, Ms. Brown, I'm going to cut you off. Broadcast services, if we can go to our next caller in support.
Next caller with the last three digits of 499. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin. Caller, please press *6 now to unmute yourself.
Hello, I apologize. This is Jody Hocking, HOCKING, from Return Strong Families United for Justice for the Incarcerated. And I apologize. Oh, please. I think I got it straightened out now. I'm here today in full support of AB 395. Really, it is time for Nevada to abolish the death penalty for all of the reasons that people have way more eloquently said than I can. I would just like to make a brief statement, quoting Sister Helen Cregan. If we believe that murder is wrong and not admissible in our society, then it has to be wrong for everyone, not just for individuals, but for governments as well. By choosing to continue to use the death penalty, we become accomplices to the death of another human being. It needs to stop. Really, it needs to stop in the name of Reginald Hayes Mason, who the state of Nevada paid $975,000 to in 2019 for the 13 years that were stolen from him when he was wrongfully convicted at 14. In the name of DeMarlo Berry, who the state of Nevada paid $2.25 million for the 22 years he spent incarcerated and was later found to be wrongfully convicted. And in the name of Kathy Woods, who spent 35 years in prison and, yes, also wrongfully convicted, and who the state just paid $2.85 million to compensate her for her years that she lost. I understand that these people didn't have the death penalty, thank God, really, or we may not have had the opportunity to correct what went wrong. Not that the money can ever give them back time, but at least we didn't kill them. I just want to take a second. On Sundays, every Sunday now, since return started, I have, I call it Sundays with Death Row. I have inmates that are incarcerated there who call me to talk about issues that they're having. Maybe it's restitution, maybe it's inhumane conditions. It could be any number of things, but the impact of talking to people who have had to sit and know that they're just waiting to die has really impacted my life and my belief more deeply than I ever did before that we need to end the death penalty. We know the system is broken, and as such, we can't continue to move as if it isn't. It's time. It's the right decision on every level. I agree with the other speakers and I'm in full support of AB 395. Thank you for your time.
Thank you, Jody. If we can go to our next caller in support.
Next caller with the last three digits of 118. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you. Chairman Yeager, members of the Assembly Judiciary Committee. I am John Arrascada, A-R-R-A-S-C-A-D-A. I'm the appointed public defender for Washoe County, and I'm qualified under Rule 250 to be lead counsel on death penalty cases. I speak in support of AB 395 to abolish the death penalty in Nevada. I could speak to you today in support by relying upon the data and material that have been presented to this committee in support of AB 395. But I think the issue of abolition of the death penalty is greater than the data. I speak in support because I view this as a true inflection point as to who and what we are as a state. We must recognize, like so many of our sister states who have indefinitely stayed in position of the death penalty or who have abolished the death penalty, most recently Virginia, they all have recognized that the death penalty and the system formed around it is broken. It is inequitable and racially determined. It preys upon the poor. It does not provide closure. It does not prevent recidivism. It does not have a deterrent effect beyond that which can be provided by life without parole. The death penalty serves one purpose: vengeance. The opposition may tell you that they screen death penalty cases to remove revenge from their decision process. Ask them, what metrics do they utilize? What is their exact evidence-based objective process? What exact considerations do they take into account on every case to ensure a uniform process to determine when to notice death and that vengeance is not a factor? I predict that if you peel the onion of the decision process back when prosecutors seek death, that it is based on an arbitrary process controlled by the makeup and mores of the decision maker. The only common denominator and uniform factor you will find in their decision-making process is that when they decide to seek death, it is revenge. In Nevada's death penalty system, almost every homicide will have an aggravator that can lead to a death notice. History has shown there is not and cannot be a uniform system that will make the decision to notice death fair-based, not revenge-based. Even the most thoughtful prosecutor cannot provide you with an evidence-based, uniform, and concrete
If
system.
I can go ahead and have
for their
you go ahead
decision.
and finish up your testimony, and if you have something in writing, please submit it.
Yes, ma'am. The opposition may further tell you that revenge is countered by their logic, compassion, and taking into account the realities of the person they are considering for death. Revenge cannot be countered by logic and compassion. If so, no one would be sentenced to death. Our courts have been tinkering with the death penalty
At
process
this time,
for
I'm going to go ahead and
45
cut
years.
you off. If we can go to our next caller in support. Thank you, Broadcast Services.
Next caller with the last three digits of 018. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. My name is Jim Sullivan, JIMSULLIVAN, and I'm representing the Culinary Union. The Culinary Union supports Assembly Bill 395 and the repeal of the death penalty in Nevada. The death penalty is perhaps the most barbaric aspect of mass incarceration in the United States, which we know disproportionately affects Black, Indigenous, and people of color. We also know that the death penalty in Nevada is racially biased. Almost 40% of the people on death row are Black, despite only accounting for about 10% of Nevada's total population. Additionally, death penalty cases are extremely costly and too many innocent people end up on death row, which is a miscarriage of justice that our state should never accept. Nevada is better than the death penalty. Over the last 3 sessions, the Culinary Union has advocated for several criminal justice bills that have started to right the wrongs of Nevada's past and make sure that all Nevadans are treated equally under the law. Ending the death penalty is just another positive step towards creating a more just system. The Culinary Union urges the Nevada Legislature to support and pass AB 395. Thank you.
Thank you, Mr. Sullivan. If we can go to our next caller in support.
Next caller with the last 3 digits of 316. Caller with the last 3 digits of 316, please slowly state and spell your name for the record. You have 2 minutes and may begin. Caller, please press *6 now to unmute and begin your testimony.
Hi, my name is Martha Sharp, MARTHASHARP, and I am a member of Return Strong with Jody. My simple statement comes down to rather a moral issue than a political policy or money or how much more it costs to have someone run through the death penalty process and trials and such. I truly believe that we are not capable of knowing whether a man or woman is innocent 100% of the time, and therefore feel that the chance that we might even kill one person unjustly should be considered by all of you. One person, yourself, your son, your daughter, your brother, your uncle, whoever. And please support the bill. Thank you.
Thank you. If we can go to our next caller in support.
Next caller with the last 3 digits of 810. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Nisa Sun, NISSATZUN. I'm a resident of Clark County, and I am the co-founder of the Force Trajectory Project and a part of the Mass Liberation Project. I am calling in support for AB 395 to abolish the death penalty, which I view as cruel and unusual. And furthermore, I find its history steeped in racism and the significant margin of error absolutely disturbing. I have also been personally impacted by the death penalty. My friend William Morva was on death row for 9 years in Virginia. William was a friend of mine since high school, a kind soul who spearheaded the anti-racist campaign, urging our high school to change their sports team mascot, the Indians. He was loved by his family and friends and was known by everyone to be a genuine, kind, loving person. After we all graduated, Will started to exhibit some strange behaviors, which seemed to coincide with the passing of his father. Along with severe mental illness, he also suffered from digestive issues that was very debilitating. In 2006, much to the surprise of his family and friends, Will committed a double homicide. He was soon convicted and put on death row. But his team, made up of legal experts, mental health experts, and his community, knew that Will was severely mentally ill. At the very least, they all felt that his life should be spared because of his obvious impairment and mental suffering. Even the murder victims' families advocated for Will's life because they themselves did not believe that killing Will would solve anything nor bring them any peace. Despite the team's efforts and the murder victims' families' plea to the state that executing Will would not bring justice, Will was executed in March of 2017. I personally find it disturbing that even in the case where the murder victim's family disagrees with the death penalty, that the state will still push on to kill. He is the last person to be executed in the state of Virginia. As you all may know, the state of Virginia just abolished the death penalty this year. It is
Go ahead and have you
bittersweet and
finish up your
frustrating.
testimony. You're at the 2 minutes.
And frustrating that they couldn't do it soon enough to save Will's life. His death has completely devastated his friends and family. The impact of his death is immeasurable. The trauma of his friends and family are experiencing are lifelong. There's no way to reverse what has happened. I ask everyone to please support AB 395 to abolish the death penalty in Nevada. Thank you.
Thank you. If we can go to our next caller in support.
Next caller with the last 3 digits of 843. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Reverend Karen Foster, KarenFoster, Unitarian Universalist Fellowship of Northern Nevada, Reno. Thank you for hearing my testimony today. It is time to abolish the death penalty. This is a religious issue and a spiritual issue for me personally and for many of us. For Unitarian Universalists, our first principle calls us to respect the inherent worth and dignity of every person. And so I'm very concerned that 100% of people on Nevada's death row are victims of poverty and therefore cannot afford legal representation of their own choice. I'm very concerned that at least 3 individuals in Nevada have been released from death row based on evidence of their innocence, and other individuals charged with capital offenses have been similarly exonerated after decades in prison. We know that persons of color are disproportionately arrested, charged, and convicted of crimes, and we're very concerned about this disparity in regards to persons who are on death row. It is time for us to create a more humane and compassionate society and abolish the death penalty. Thank you.
Thank you. We can go to our next caller in support.
Next caller with the last 3 digits of 666. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. My name is Stacy Newman. That's STACYNEWMAN. I'm a public defender in Las Vegas, and I represent death row inmates. I'm also a member of the Las Vegas chapter of the National Lawyers Guild. I'm testifying today on behalf of the Las Vegas NLG to emphatically support passage of AB 395. The death penalty in Nevada is demonstrably flawed for all the reasons you've heard so far. We'd like to emphasize some of those reasons why the death penalty must go. First, Nevada's death penalty ensnares the innocent. At least 3 death row prisoners have been saved from execution based on evidence that they were innocent. Other people who have faced the death penalty were also exonerated after languishing in Nevada prisons for decades. This error rate is inexcusable and demonstrates that Nevada cannot and should not be trusted to wield this irreversible power over someone's life. Second, Nevada's death penalty is racially biased. As put by some of our speakers in the Equal Justice Initiative, the death penalty is a direct descendant of racial terror lynching. In addition, In addition to the overrepresentation of Black people on Nevada's death row, the death penalty is up to 3 times more likely to be given for the murder of a white person than the murder of a Black person. These statistics demonstrate that the legacy of racism is indeed present in Nevada's death penalty. Third, Nevada's death penalty does not serve legitimate purposes of punishment. There's no evidence that the death penalty deters others from committing capital crimes. The rates of violence amongst death row prisoners remain lower than general population prisoners. And the constitutional requirements that death penalties meet heightened standards of scrutiny means that death penalty litigation can last for decades. All of these factors undermine the penological justification for keeping the death penalty. And fourth, the people on Nevada's death row are overwhelmingly poor and come from disadvantaged backgrounds. The United States Supreme Court requires that capital punishment be limited to the worst of the worst offenders. But Nevada's death penalty seeks to punish the most marginalized of the marginalized instead. In closing, the Las Vegas chapter of the National Lawyers Guild urges lawmakers to pass AB 395 to rid Nevada of the death penalty once and for all. Now is the time. Thank you.
We can go to our next caller in support.
Caller with the last 3 digits of 303. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Alex Spellman, Spelman, and I'm providing this testimony in support of AB 395. I'm a graduate of UNLV's Boyd School of Law and now serve our community as a local public defender representing individuals on death row. The question for this committee is not about who deserves to die, but rather what power and resources we should entrust to our government. The death penalty is a multi-million-dollar program that does not deter crime, it has racially biased outcomes, it does not provide material aid to victims, and innocent individuals are continually discovered on death row. We've been trying to reform the death penalty for decades to somehow make it fairer, but there still remains an overwhelming racial bias in the use of the death penalty, particularly against Black folks. While Black Nevadans comprise only 10% of the state's total population, they make up about 35 to 40% of those on death row. Research shows official misconduct in capital trials is more frequent when the defendant is Black. False murder convictions are 7 times more likely when the defendant is Black. The death sentence is more likely to be imposed when the defendant is Black, and the death penalty is utilized less frequently when the victim is Black rather than white. This fatal punishment is disproportionately applied against Black folks and on behalf of white folks. It is time to abandon the existence of this irreparably racist institution. Further, innocent folks on death row should shock everyone. You've already heard the statistics. For most sentences, though, we have at least something of an available fail-safe, reversal and compensation for the wrongfully convicted. Yet the execution of an innocent person, of course, is irreversible, and the dead cannot be compensated for their erroneous execution. And we know how to fix it. Less drastic, less expensive, and reversible alternatives exist that would still allow Nevada to achieve its public safety goals with the same degree of effectiveness without assuming these horrible risks. I think Nevada is better than this, and I urge you to support this bill to abolish the death penalty, bringing Nevada in line with nearly half of the U.S. states and the vast majority of countries on Earth. Thank you for supporting this bill. It's the right thing to do and will help make Nevada a better place for all of us.
Thank you. If we can go to our next caller in support.
Caller with the last 3 digits of 590. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Makaja Daniels, and I am a member of the Black Lives Matter UNLV chapter, and I'm studying to get my master's in public health at UNLV as well. I want to take the time to really expand on the implications of the racial bias within the death penalty and address how we can come together as a state to set priorities. So the Southern Nevada Health District declared racism as a public health crisis on June 4th of 2020, and the state of Nevada declared racism as a public health crisis in August 5th of 2020. So racism is a system that disproportionately affects and unfairly disadvantages individuals based off of race. And that's a paraphrase from the president, Kamara Phyllis Jones, from the American Public Health Association. And so to achieve health equity, we must address injustices caused by racism. And so working together, I believe that we can create the change necessary to prohibit a system that has clearly demonstrated a racial bias, as well as cross moral implications of killing people. So with that, I conclude. Thank you so much for your time.
Thank you, Ms. Daniels. If we can go to our next caller in support.
Next caller with the last three digits of 464. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin. Caller with the last digits of 464. Please press *6 to unmute yourself to begin your testimony. We will move on to the next caller with the last three digits of 338. Caller with the last three digits of 338, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you. For the record, Nathaniel Erb, Nathaniel, last name ERB, here on behalf of the Innocence Project in support of AB 395. In signing the latest abolishment of the death penalty, Governor Northam of Virginia noted we cannot give up the ultimate punishment without being 100% sure that we're right. We cannot sentence people to the ultimate punishment knowing that the system doesn't work the same for everyone. The primary lesson that we must be learned from those exonerated in Nevada is that our criminal justice system can and does convict innocent people. The convictions of Nevada's exonerees span more than 3 decades. These include people sentenced to death and more, as you heard this morning, against whom the death penalty was sought but did not succeed. 185 people have been exonerated from death row over the last 48 years across the country. Included among that group are many Innocence Project clients and survivors. The National Academy of Sciences, as heard this morning, determined that the likely number of innocent people on death row or already executed is at least double those exonerated. The case of exonerees in Nevada alone showed that a conviction of the innocent is not tied to one prosecuting office, one precinct, one judge, or even one quarter-century's approach to criminal justice. While we can and must make reforms, we cannot escape the fallibility of a system that determines who should die. Our written testimony goes into further details on the data surrounding official misconduct, false confessions, and other miscarriages of justice that are pervasive throughout the case of exonerees, as well as the barriers for proving innocence once convicted. We cannot state with certainty that Nevada's criminal justice system will always uncover actual innocence in capital cases. Given the range of potential error, even an excellent judicial case review simply cannot provide fairly to be expected to identify every miscarriage of justice without fail in a timely manner to ensure that no person is unjustly executed. It is for these reasons expounded in our written testimony that the Innocence Project supports AB 395. Thank you.
Thank you. If we can go to our next caller in support.
Caller with the last three digits of 237. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, committee chair and members of the committee. My name is Marlene Lockard, Lockard, representing the Nevada Women's Lobby. We are in support of AB 395 for all the reasons and the in-depth testimony that you have heard this morning and the experiences of individuals that you have heard from. There are so many wrongful convictions, uncertainty in the process, the length of the process, not to mention the cost to the state in investigating and conducting death penalty cases. So we feel this bill is worthy of your support and passage and urge your positive consideration. Thank you.
Thank you for your testimony. I'm going to go to our last caller in support of Assembly Bill 395. Broadcast Services.
Thank you. Caller with the last three digits of 576. Please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last three digits of 576, please press *6 to unmute yourself and begin your testimony.
Chairman Yeager and members of the committee, my name is Thomas Hassan, Hassen, and I am a Human Rights Commissioner for the City of Reno, but I'm here today to represent myself and speak in support of AB 395. My first experience with Nevada law enforcement resulted in 4 firearms in my face. I was 13 and tried to explain that I was just waiting for a friend, but I guess I wasn't convincing enough. And as disturbing as that might sound, it's by no means extraordinary. Racial undertones and overtones overshadow much of the history the legal apparatus established and enforced laws of American society. And though some may debate the reasons for existing disparities, what we can largely agree on is that something is deeply wrong here. If only 24% of U.S. adults have confidence in our criminal justice system, a crucial question must be asked. Why should such a distrusted system have the power to make a decision as permanent as death? As a Black Nevadan, I've seen firsthand that the flaws we are so quick to criticize in other states' legal systems are just as present and dangerous right here in our home state. It doesn't take an experience like mine to understand that we are not an exception to the rule of racialized policing, though it does serve as a blunt reminder. The same deadly features of our criminal legal system that more than 2,000 American cities and 60 different countries protested last summer are the same ones governing the death penalty, and we need to start treating it that way. The system of punishment is not working the way we think it should, and the only way we can stop it from making mistakes we won't be able to fix is by passing AB 395 and abolishing the death penalty in Nevada. Thank you so much for your time.
Thank you for your testimony. At this time, I am going to close testimony in support of Assembly Bill 395. I recognize that there are quite a few people that are still on the line in wanting to testify in support. I will encourage all of those people that are still on the line to reach out to the committee members, as well as submitting their comments in writing within 24 hours of this hearing. At this time, we are going to shift into opposition testimony. I have allowed 4 individuals to testify in opposition. I will allocate that same amount of time that I did for testimony in support in opposition. There are 4 individuals that are here to testify in opposition. Like I said on the Zoom, I am going to give them a little more leeway outside of that 2 minutes. To allow them to expand on their position. I think that this conversation is deserving of a more balanced approach in addressing this. Again, for our committee members, there will be an opportunity after opposition testimony on the phone lines to be able to ask some additional follow-up questions based on both the testimony in support and the testimony in opposition. And I would ask our presenters that are in opposition on the Zoom to remain on the line for those questions. And again, I will direct them to have one person direct the answer the question instead of doing this round table, round the robin, kind of like everyone answer the question. And so with that, I will ask our people in opposition to please turn on their cameras. And do you have a particular order that you wanted to present in? I'm looking here, I see Mr. Ingram, Mr. Wolfson. I believe Mr. Hicks is also on the line, is that correct? Gentlemen, did you have, and I think Ms. Weckerly, is she on here as well? I see here. Did you have a presentation order that you wanted to go in?
Madam Vice Chair, this is Tyler Ingram. I think I'd plan to go first, if that is okay with you.
That is fine, Mr. Ingram. Please go ahead and state your name for the record. I'll remind all the speakers, and then go ahead and begin when you're ready.
Thank you, Madam Vice Chair. This is Tyler Ingram. I am the Elko County District Attorney, and I also am the president of the Nevada District Attorneys Association, which is made up of all 17 Nevada's elected DAs.
I'm here in opposition to AB 395 on behalf of Elko County DA's office and the association. I've been a prosecutor for over 10 years, so I don't speak before you today pretending that I have more lawyer experience than some of you in the room or at your houses. And I don't have more experience than Mr. Hicks from Washoe County or Mr. Wolfson from Clark County. However, I do imagine that I have more rural prosecution experience than most people attending this hearing today. I hope that I'm wrong, but it can seem that rural counties are looked at through a somewhat different lens, especially as it relates to criminal justice issues like the death penalty. I simply want to reiterate that the prosecutors in my office pass the same bar exam and apply the same law that the prosecutors in our larger counties do. We apply the same ethical rules and apply the same measure of compassion and justice for both defendants and for victims. We do not indiscriminately apply the death penalty. Despite some people's belief, we are not rogue. We may be different in some ways, but we aren't self-righteous vigilantes who abuse the legal process. We are kind, we are understanding, and we are every bit as confident as every other lawyer in this state. We are not hard-nosed. We are not bulldog. We are advocates just the same way that defense attorneys are advocates. During my time with Elko County, our office has reviewed at least 10 cases for death penalty decisions and have pursued the death penalty in 2 of those cases, with the possibility of adding a 3rd in the near future. Those 3 examples represent cases that are unthinkable, barbaric, and devastating for our entire community. An argument presented last session on a similar bill was that a prosecutor can fit almost any first-degree murder case into at least one of the aggravating factors. Even if we accept that as true, those who make that argument seem to overlook the fact that that's not the end of the line. We, as prosecutors, also weigh the aggravating factors against those mitigating factors in making our decision to seek the death penalty. My office chose in at least 6 of the death penalty eligible cases that we could not ethically ask a jury to impose a death penalty because we didn't believe that the aggravating factors outweighed the mitigating factors. Likewise, if we seek the death penalty, there is yet another check on its imposition. A jury must carefully weigh aggravating and mitigating factors. If a jury decides that it's appropriate punishment, then I respectfully believe that lawmakers shouldn't second guess the careful consideration from jurors who made the decision on behalf of their community after hearing all the evidence. I wish people understood and gave prosecutors credit for the fact that we have just as much of an obligation to protect a defendant's constitutional and statutory right as their defense attorneys do, and we take that responsibility seriously. In making a decision on whether to pursue the death penalty, I nearly always ask for the victim's family's input. That's an uncomfortable talk to have. I have witnessed firsthand nearly all perspectives about the death penalty from those family members. Some think that nothing but the death penalty would be justice, and others believe that life in prison is justice to them. Again, in reviewing the minutes from last session on a similar bill, an argument that imposing the death penalty does nothing to provide justice or closure to a family is just simply too much of a generalization. How can any one person individually proclaim that it isn't justice for the rest of the victims' families? Respectfully, we don't have that right. Individualism should be embraced, and we should not second guess their feelings. Removing the death penalty will undoubtedly remove that option for those who feel like the death penalty is justice. In making this point, I never intend to diminish or disrespect those people who believe that the death penalty isn't justice for them. I simply respect uniqueness. Please do not make the cost of the death penalty the most important factor. In a time when it seems that we are focused on decriminalization and lessening punishment for criminal behavior, let's not forget that there is value in justice and there is value in punishment without regard to monetary costs. Thank you, Madam Chair, Vice Chair.
Thank you, Mr. Ingram. I believe next we have Mr. Wolfson.
We do. Good morning, Madam Vice Chair. Thank you, and good morning to members of the committee. I'm Steve Wolfson. I am the Clark County District Attorney, and on behalf of the Clark County District Attorney's Office, we oppose this bill, and I want to talk about the reasons why. Rather than rehashing the same debate in polarizing absolute terms, I suggest that the perceived defects in the administration of the death penalty be addressed in practical terms. My preference for this is based on 2 beliefs. First, I believe the death penalty should be an available punishment option here in Nevada. The events of 1 October and more recent tragedies in Colorado and Georgia reinforce this belief. Yes, October 1, 2017 was a day that will forever live in infamy. An evil person murdered 60 people. Yes, 60 people. Not like 8 in Georgia, not like 10 in Colorado. 60 people were shot in cold blood. If the killer in the 1 October massacre had not cowardly taken his own life, I would have not hesitated to have sought the death penalty in that case, and I would have personally prosecuted that killer. We seek the death penalty in killings involving children, where extreme torture or mutilation is involved, or where there are multiple decedents. We don't make these decisions lightly. The criminal justice system relies upon graduated punishment. And if the appropriate punishment for a single murder is life without parole, how do you punish a person who commits multiple murders? Should we punish someone who kills one person the same as someone who kills 2, 3, 10, or 60? I say no. Let me briefly give you some examples of graduated punishments. If a person drives while impaired with no accident or injury, it's a misdemeanor DUI. However, if a person drives and engages in the same behavior and causes substantial bodily injury or death, the charge is elevated to a felony. Another example is the crime of battery. If a person uses force against another person, it's a misdemeanor battery. However, if that same person uses force against a person they have a special relationship with, it constitutes domestic battery with increased punishments. Another example is the category of theft crimes. Based upon the amount stolen, a person can be charged with a misdemeanor, gross misdemeanor, or felony. Another example is burglary. We differentiate between commercial and residential burglaries. And finally, the crime of sexual assault. If a person commits a sexual assault upon another adult, there are certain penalties. However, if that same person commits a sexual assault upon a child under the age of 16, there are increased penalties. And again, against a child under 14, there are even increased penalties beyond that. The crime of murder should be no different. If we abolish the death penalty and a person who is convicted of first-degree murder can only be sentenced in 2 ways, life with or without the possibility of parole, that's not right. That is why we have the graduated punishment of the death penalty for those who fall into the category of the common phrase, which is used by so many, including myself, the worst of the worst, because there are differences between perpetrators and crimes. While I support the death penalty, I am not insensitive to the concerns raised by those. Most voters in Nevada still support the death penalty. I've heard about different polls, I've seen different polls, but my information is the majority of Nevadans still support the death penalty. So instead of having the same conversations that end up in wholesale endorsement or abolition of the death penalty, I would like to move away from the symbolism and toward a considered assessment of what can be changed to address some of the concerns of those who oppose the death penalty. In my travels, most people who complain about the death penalty complain about the fact that it's taking so long, not that we shouldn't be imposing it. It is not because we do not return a verdict of death, we are just not getting it done. How about looking at the process? One concern is that we frequently raised is the fear of a wrongful conviction resulting in the imposition of the death penalty. I understand that, I get it. As an elected district attorney, I believe there would be no greater tragedy than this, convicting a person who is not guilty. Nevertheless, in most capital cases, the evidence of guilt is overwhelming. If the perpetrator of October 1 had not committed suicide, there would be no question as to his guilt, much like the cases in Colorado and Georgia. To address the concern of a wrongful conviction, the legislature could require that the jury make an additional finding of no residual doubt at the penalty phase of a trial in order to proceed with consideration of the death penalty. Another concern I've heard is that too many cases are capital. Personally, I have filed far fewer death notices than other Clark County district attorneys. I strongly believe that the death penalty should be reserved for the very rare and extreme circumstances. That's what I've done in my almost 10 years as being the district attorney here in Clark County. In fact, last year, we only filed 2 notices of intent to seek the death penalty. And I want to remind this committee that we don't impose the death penalty. Prosecutors file the notice giving the jury the option. It's the juries that determine whether death or a lesser punishment of life with or without is appropriate in an individual case. If one holds the opinion that the death penalty is morally untenable under any circumstance, these suggestions will not be persuasive. But if there is a genuine concern about the application of the death penalty versus the idea of it, the solution is to engage and refine the law, not abandon and option the voters' support. Thank you.
Thank you, Mr. Wolfson. If we can go next to Mr. Hicks.
Good morning. My name is Chris Hicks, and I'm the elected Washoe County District Attorney. Thank you for giving me the opportunity to address this committee today. The U.S. Supreme Court and the Nevada Supreme Court have both held that capital punishment is in fact constitutional. It is legal in most of our states, and it has been the law in Nevada since statehood, 157 years, minus the 4 years that it was abolished federally. A 2017 Mellman Group poll conducted in Nevada found that 66% of voters support keeping the death penalty. A recent 2021 poll that was referenced in the support section of this bill, conducted in Nevada, found that 36% of Nevadans believe the death penalty is the most appropriate penalty in every first-degree murder case. That's despite its sparing and judicious use by prosecutors in those cases. AB 395 eliminates a community's ability through impaneled jurors to consider imposing the death penalty in our state's most heinous murder crimes. And it commutes the death sentences of all the horrendous murderers currently on death row. Lawful sentences administered by juries and relied on by devastated victims. That is a demographic you all need to carefully think about when debating this bill. In every death penalty case in Nevada, entire families become victims. The victims who suffered unthinkable fates, and their loved ones who carry the pain and suffering of their loss and the gut-wrenching agony that comes with knowing what happened. These families carry that every day for the rest of their lives. In my time in the Washoe County District Attorney's Office, which is just over 16 years, 2 death sentences have been sought and imposed by a jury, and 1 is currently being prosecuted. Those cases represent the worst of the worst, and just 1% of the murder cases prosecuted in that same time frame. As you contemplate this bill, I think it is important that you consider what these murderers did. On September 14th, 2006, Tamir Hamilton raped, tortured, and murdered a 16-year-old girl named Holly Quick in her own bedroom. He took his time. He stabbed her over 40 times, and nearly decapitated her. Holly's mom found her the next morning. 2 weeks before that, Hamilton repeatedly and violently raped a 20-year-old girl. A jury sentenced him to death. In 2017 and early 2018, James Bila committed a series of rapes on young college girls in Reno, Nevada. His first victim was raped at gunpoint on the concrete floor of a parking garage on the UNR campus as she was leaving class. The second victim was choked to unconsciousness as she returned home from studying and was kidnapped, where she was then raped repeatedly. Bila's last victim, Breonna Dennison, was abducted, raped, and then strangled to death. Her lifeless, naked body was discarded by Bila like a piece of trash in a vacant lot. The jury sentenced him to death. It is currently alleged that in January of 2019, Wilber Martinez Guzman violently murdered 4 people in their homes in northern Nevada over a 7-day span. Connie Kuntz was shot in the home she shared with her 87-year-old mother, who found her body. Sophia Rankin, age 74, was shot multiple times in her home where she lived alone. Lastly, Sherry and Jerry David, age 80 and 81, were shot multiple times in their ranch home in Reno. My office and the Douglas County DA's office are currently prosecuting this case and plan to ask a jury to sentence Martinez Guzman to death. Simply put, some crimes are so heinous and inherently wrong that they demand strict penalties, up to death. Most Nevadans recognize this principle as just and want to keep this option when sentencing these worst of the worst offenders. Contrary to what's been suggested by proponents of the bill today, elimination of the death penalty will not create a windfall of savings. The death penalty is sought so infrequently that the cost difference will be minimal. Moreover, the state LCB audit that you've heard about today, done in 2014, was misleading. Prosecutors did participate in that audit. That audit was based on unverifiable estimates and attempted to quantify costs that exist in county budgets, whether there is a death penalty or not. In fact, AB 395 will waste money, as it will render useless the $860,000 this legislature appropriated just 3 sessions ago to build a new facility where lethal injection can be administered. There is the drug to commit or to carry out an execution. Correspondence with the former director of the Nevada Department of Corrections in 2017 reveals that the state is in fact able to carry out a lethal injection should it be ordered. And 17 executions occurred in the United States just last year. Our neighboring state of Arizona has a new supplier of the lethal drug and will start executions again soon. Another point that was made was that life without the possibility of parole is just that. The person will live in prison for the rest of their lives. That is not true. We have a state pardons board that is comprised of our elected Supreme Court justices, our governor, and our attorney general. And they regularly consider the commutation of life without murder sentences. Just last week, my office argued a case in front of the Pardons Board where they were considering commuting a life without the possibility of parole first-degree murder sentence to life with the possibility of parole. My point is, life in prison is not necessarily life in prison. I would encourage this committee, like Mr. Wolfson did, to consider a different policy, fixing our damaged death penalty system, like a majority of voters in California voted to do in 2016. The policy of our state should be to uphold the rule of law and respect are court-ordered sentences. The victims of these heinous crimes deserve it. Moreover, we should not overlook the reality that these victims will not be the last. It is a terrible fact that there will be more victims, and they all deserve justice. Thank you.
Thank you, Mr. Hicks. And you had mentioned something about the LCD prepared financial audit. So I would encourage all of our members to go back and look at that. I don't necessarily agree that our LCD staff did not do their jobs appropriately. So I would encourage everyone to go back and look at those documentation on their own. And just for our members, I know that we had some comments about the polling that was referenced, as well as some of the other statistics that you used. And just to let everyone know that I know that I've been in contact with Mr. John Jones, who represents and is the lobbyist for the District Attorneys Association, and he will be getting that information to the committee members as well. And with that, if we can go next to, I believe our last presentation on the Zoom in opposition is Pam Weckerly.
Morning. Thank you. My name is Pam Weckerly. I am the team chief of the Clark County District Attorney's Office Major Violators Unit. I supervise the prosecution of murder, gang, and gun crimes cases. My personal caseload consists entirely of murder cases. As was raised this morning by numerous speakers in support of the bill, the cost of the death penalty or capital punishment is often raised as a reason to abolish it. I've been prosecuting murder cases for 18 years as a deputy district attorney in Clark County, and I've been a DA longer than that. And I must confess that I've never really understood this argument. First, at a basic level, as discussed by the elected district attorneys, if they are judicious in deciding which cases to seek death in, there is an automatic and immediate cost savings to the judicial system and also to respective offices on the prosecution and defense side. Second, in preparing for this hearing, I read the minutes from the 2017 hearing on the death penalty, and many references were made to the 2014 audit of the costs of the death penalty. In fact, I was actually interviewed in 2014 by auditors, and I sincerely believe the auditors were honestly trying to produce an accurate result for the legislature to make a decision. The problem is that criminal law and criminal prosecution is sort of a fact-specific business. As an overview, I recall auditors asking me how much time in hours I spent on capital versus non-capital murder. I told them I could not make that sort of distinction. As a trial lawyer, my concern is proving my case beyond a reasonable doubt, whether it's capital or not. So the hours I spend in preparation are devoted to meeting that burden. I've spent countless hours on cases that I ultimately had to negotiate to an involuntary manslaughter charge, which carries a penalty substantially less than the death penalty. In fact, in general, I would say that capital cases almost always have a tremendous level of proof. And I don't say this to be flippant or to suggest to this committee that capital cases require no preparation. They do, and I can tell this committee that no one I work with minimizes or dismisses the gravity or solemnity of the prosecution of a capital trial. Those cases weigh on us as prosecutors, but if the question is about working hours, there is no easy calculation based on whether the case is capital or not. The inconvenient truth is that all cases are different due to the facts and the level of proof presented. The good news for taxpayers in Clark County is that I am a salaried worker. I get paid the same amount whether I work 40 hours or 100 hours in a particular week. So I don't cost the taxpayers any more money if I'm prosecuting a capital case or not. The same is true for my colleagues on the defense side at the Public Defender's Office and Special Public Defender's Office. The third point with regard to costs made by the defense and by Mr. Coffey this morning is that capital work requires the defense to work up a mitigation case for sentencing. They have explained that this means that they must trace their client's personal history from birth to the point of the murder in an effort to spare a client the maximum punishment. I have been involved in several of these hearings, and I can attest to the dedication and work put forth by defense attorneys in these mitigation cases. From my experience, they do a remarkable amount of work and truly leave no stone unturned, and rightly so. Every fairness and consideration is owed to a defendant being sentenced for murder. Where I question the cost savings alleged by my colleagues on the other side is this. If we are talking about depriving someone of ever getting out of state custody, how could those same mitigating circumstances suddenly become irrelevant? Every mitigating circumstance would be just as important if sentencing as death penalty weren't an option. And if that is the case, there would be no or very little cost savings. The mitigation case would be to avoid life without the possibility of parole rather than death, and no savings would result. I am not here, however, to tell this committee that in my experience, the cost between capital versus non-capital is identical. In truth, I think on average, capital cases do cost more, but it is slightly more and is case dependent. In my estimation, it is nowhere near the numbers the audit suggested. All litigation ends up in post-conviction appeals, PCR filings in state and both federal court, and that is whether the case is capital or not. In the end, the question is whether this cost is warranted in a particular case, and that lies in the discretion of elected district attorneys who are elected by the voters in their communities. I can tell this committee, however, that when I meet with families of murder victims, more families than not ask about whether the death penalty is an option. And I would respectfully say to this committee that those families are part of the community as well. Thank you.
Thank you, Ms. Weckerly. And because I want to make sure that we are also able to incorporate people on the phone. If next we can have broadcast services go to those in opposition of Assembly Bill 395. And if we can begin, I'd remind callers to please clearly state and spell their name for the record and limit your testimony to 2 minutes.
Thank you. For callers wishing to provide testimony in opposition of Assembly Bill 395, please press star 9 now to take your place in the queue. We will begin with caller with the last 3 digits of 105. Caller, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Lynn Chapman. I'm the State Vice President of Nevada Families for Freedom, LYNNCHAPMAN. I do not have any revenge in my heart. It's only sorrow and loss. And I keep hearing about cost. What about the cost to the families of the victims? When you get the phone call that your loved one has died, the first thing you think is a car accident or heart or what? When my father called me about my brother's death, he couldn't even speak. He was so overwhelmed. It took a while for me to find out what in the world happened to my brother. He was working in a logging industry as a scaler. He worked at a place that was a very small town. There was a man there that was reckless in his work, and it was putting people's lives in danger. So my brother was asked by all the other guys to write the BLM and to the owner of the lumber company. And this reckless man knew my brother did that. 2 weeks later, my brother was going into the employee parking lot. This man was in a log loader, which is a huge vehicle, and he was illegally in the employee parking lot with that vehicle. When my brother was about 25 feet away from his parking spot, this man backed up that log loader and ran over my brother, and he crushed him to death. That was a violent death, and it is barbaric. The torture of victims is barbaric. It affects the families' lives forever with a horrendous, a barbaric way that our family members are killed and murdered by people. And I wanted to ask, how many innocent people had died at the hands of others? And in a lot of cases, brutally murdered at the hands of others. What do we tell them? What do we tell the families? The cost to the families is no way to even put a dollar amount on it. We seem to be able to get meds to end life for assisted suicide people, but not for murderers. What is wrong here? This is terrible. And I please ask to oppose AB 395. This is not about revenge. It's sorrow and it's loss for the victims' families. Thank you.
Thank you for your testimony. Broadcast Services, if we can go to our next caller in opposition.
Next caller with the last three digits of 012. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hi, my name is Steve David. I'm representing my siblings, Debbie, Diane, and Larry. Our father, Jerry and Sherry David, along with Connie Kuntz and Sophie Renkin, were brutally murdered senselessly for the simple reason of stealing and having time to steal around them while their bodies lay in their homes. The arguments in ineffectiveness of the death penalty, the system, I believe, is flawed and broken, and it needs to be fixed in order to work in the appeals and the constitutions and time constraints. As far as cost, what is the value of my dad, mom, Connie, and Sophia? Place a value on their lives, if you can. As far as costs, I'm going to refer to Charles Manson, spent 40 years in the California correctional system. And the cost, it would have been easier and less money to execute him. I'll mention I was also a correctional officer in the penal system for 25 years, working investigative services unit, and was a disciplinary officer for most of the years. And I'll tell you, these people have no remorse. As far as for a peace of mind for the family, the person serving life, knowing that they can communicate and have a social fellowship with their families that we're not afforded, is appalling. Forensics. Nobody's talked about forensics. Forensics are so advanced from the 70s that the probability of a case, somebody being found guilty when they're innocent, due to the forensics these days, narrows it to almost nilch. I kept an open mind during this thinking.
I'm sorry, sir. Can I get you to wrap up your testimony and submit any additional comments in writing?
I will. Thank you very much for your time. And I oppose this bill and appreciate your consideration. Thank you.
Thank you. Broadcast Service, if we can go to our next caller in opposition.
Caller with the last three digits of 080. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Candy Rankin, Rankin. My sister, Connie Kuntz, was the first murder victim in a senseless spree that ended with 4 innocent people dead. I have always been in favor of the death penalty, And if any case truly justifies that sentence, this would be it. When a grown person makes the choice to kill 4 people, that is the ultimate selfish act and should be penalized as much as the law allows. My sister Connie was the baby of the family, loved by everyone and knew no stranger. When our 80-year-old mother found her lifeless body, I can't imagine the pain she must have felt. Connie was her friend and caretaker. Your children aren't supposed to die before you. Having to call my brother and tell him that his baby sister was shot and killed for the purpose of drug money was the worst thing I've ever had to do. Connie has a daughter, Madison, who was only 21 when her mother was murdered. They were the best of friends, did everything together, spoke every day, and had a love for Disney that I have never seen before. Why the death penalty, people ask? Because a murderer who feels that they are justified in taking someone else's life, someone else's loved one, should not get the option of certain freedoms afforded to those in prison. We miss Connie every day, think of her every day, and try to, try to think of only the good and fun times. For these reasons and so many more I don't have time to explain, I feel very strongly the death penalty should not be abolished. Thank you for allowing me to speak today.
Thank you, Ms. Rankin. We can go to our next caller in opposition.
Caller with the last 3 digits of 158. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Carolyn Sullivan, Carolyn Sullivan. My husband, Police Sergeant George Sullivan, was brutally killed in the line of duty in 1998. Please understand some of the details of this murder. Sayosi Venisi stalked George, waiting for a moment when he was alone. As George exited his vehicle, Venisi used a hatchet and hit George about the head and neck 25 times. Think about that, 25 times. That's rage and hatred. Can you imagine what George must have looked like? Did he have a face left? The argument here is that AB 395 will save money. If you are concerned about cost, then fast track the death penalty cases. That legislation was passed many years ago, but the legislature never funded it. Fast tracking would be the deterrent that is a cornerstone of the law. George's murder was particularly egregious, not just because of the violence, but this crime was planned well in advance. Sayosi bragged to his family about killing a cop for several days prior. The night before he killed George, he was out stalking police officers who appeared to be in a vulnerable position. Investigators also reported notches in the doorway of his home where he had been practicing with a hatchet. He is a very smart man. When apprehended, he had a physics book in his backpack. He is calculating. He wore a wig the night of the murder, trying to conceal his identity. In 23 years, he has not taken responsibility for his actions. He knew right from wrong. After killing George, he stole his weapon and duty belt, including his police radio, then stole a car, held up a convenience store for cash, and fled to Salt Lake City, where he was apprehended 3 days later, threatening police with George's weapon. The clothes he had been wearing that night were found in his cousin's apartment in a bag covered in George's blood. Could Venisi kill again while in the general population of prison, a prisoner or a correctional officer? He was violent time and time again in the Washoe County Jail, both after his arrest and again while awaiting trial. A special team from the jail was forced to subdue him just to move him around within the facility. He attacked the officers time and again. If you have the stomach for it, pull the Venisi file. Look at the pictures taken at the scene and at the autopsy. Then imagine someone you love suffering 25 blows with a hatchet to his head, face, and neck. Some murders are so heinous that only punishment should be a final elimination for society for the protection of her citizens. Please protect us from these horrific criminals. Do not pass this bill. Fix the system instead. Thank you.
Thank you. Broadcast Services, can we go to our next caller in opposition?
For callers wishing to provide testimony in opposition of Assembly Bill 395, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 377, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, my name is Jennifer Otremba. It's Jennifer Otremba. I am here in opposition of this bill. I would like to tell you about my precious daughter, Alyssa. She was my oldest of 3 girls, and my world was shattered when she was brutally murdered. September 2nd of 2011, Alyssa was walking home from borrowing a textbook from a friend. It was 6:38 p.m. when she texted me that she was walking home and her phone was going to die, but she would be home within a half hour. Exactly 30 minutes later, I texted her and there was no response. I called and no answer, and I immediately started searching for my 15-year-old daughter in nearby parks, and I talked to anyone I could see to see if they had seen Alyssa. I called the police and had an officer at my home while others were patrolling and keeping a lookout for a girl fitting her description. It was 24 hours later when her body was found approximately 300 feet behind our home in a vacant desert lot. As the details unfolded, I learned that Alyssa was within feet of the pedestrian gate at the end of our street when she was attacked by 19-year-old Javier Righetti. He had left his home with a knife from his kitchen. He spotted her walking, and he proceeded to follow her for a couple of blocks before he attacked. He kidnapped her, dragging her out into the desert lot. The uneven terrain and bushes made it so that no one could see them as he sexually assaulted her and then raped her. He tortured her, stabbing her more than 80 times in her head, neck, body, and then carved an LV for Las Vegas into her thigh because it made him feel gangster. Just when you think it can't get any worse, he returned hours later and poured gasoline on her, and he lit her body on fire. The coroner had to use dental records to identify her mutilated body. During the autopsy, the tip of the knife was discovered and had broken off in her skull. Her remains were in such bad condition that we were advised not to see her because we shouldn't remember her like that. There are no adequate words to describe what this horrific loss has done to our family and our community. Every area of our lives were affected by the decision of this stranger. It has divided a family. It's created physical and mental health problems, causing unending nightmares, anxiety problems, and much more. But in the midst of the ongoing struggles, we continued to cling to the belief that justice would prevail. We waited patiently for 5.5 years for Alyssa's murderer to go to trial. There was justice to be served.
Can I get you to please wrap up your testimony? You are at 2 minutes. And if you have any written documentation, please submit it. You can finish up, ma'am.
Thank you. March 16th, he was found guilty, and on March 21st of 2017, a jury sentenced Javier Righetti to a gruesome murder of my daughter, Alyssa. It was 8 days after that death that I appeared before this committee to testify on behalf of justice for my daughter. I believed that it had finally prevailed, and although he'd not killed before, at his own admission, he had assaulted and raped before. And Alyssa wasn't his first victim, but I thought she would be his last. However, the media reported last year that he stabbed another inmate, sending him to the hospital and then put on life support. Alyssa didn't deserve to be taken from us in this horrific way. Javier earned his punishment. He did not consider Alyssa's life, so why should his life be considered? Our family waited a long time for justice to be served.
Ma'am, can you go ahead and finish up now?
Death is a fair sentence for what he chose to do that day. I waited 5.5 years for justice for my daughter, and if I have to continue to fight politicians for the rest of my life to ensure that justice is served, then I will do that. Thank you.
We are at 40 minutes. I don't believe we have anyone else on the line in opposition. Broadcast services, can I confirm?
Thank you, Madam Vice Chair. There are no further callers at this time.
Thank you. And just for the record, I did allot for 40 minutes in testimony in support of Assembly Bill 395, and we are right at 44 minutes for testimony in opposition of Assembly Bill 395. This time, broadcast services, can we go to the line and to receive testimony in neutral of Assembly Bill 349? I would remind our callers on the line, especially those that potentially were still on the line in support, this is a time for neutral testimony. Just keep that in mind. Again, please state your name and limit your testimony to 2 minutes. Broadcast services, may we begin?
Yes, thank you. For callers wishing to provide testimony in neutral of Assembly Bill 395, please press star 9 now to take your place in the queue. We will begin with caller with the last 3 digits of 447. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning. My name is David Figler, spelled D-A-Y-V-I-D, F like in Frank, I-G-L-E-R. While it may come as a surprise to some that I would, or that anyone could be neutral on such a hot subject matter for our state, I indeed come that way for a number of reasons. First of all, I am a criminal defense attorney who is Rule 250 qualified to do capital defense work and have been doing such since the 1990s. I was one of the litigators involved in a case in the Nevada Supreme Court which overturned the 3-judge panel's ability to impose a death sentence, which unfortunately was not applied retroactively, but did start from December 2002 forward, leaving it to juries. The reason I come before this committee today in neutrality is simply because it leaves so many challenges of our prison and punishment and district attorney abuses that all add up to a broken system unanswered. We heard testimony in opposition today that says that this is reserved for the worst of the worst, but we understand that the worst of the worst is an undefined term and gives unfettered power to the government. They say it's used judiciously, but there are so many examples of crimes themselves that are worse than those that were given as examples where the death penalty was not imposed. Indeed, all first-degree murder cases are eligible for the death penalty. There is no required narrowing, and the Nevada Supreme Court has not squarely addressed this lack of narrowing, but is instead deferred to the legislation. So while I applaud the efforts to rein in and create a fix by ending the inappropriate killing of the incarcerated, the measure itself does not address the bigger issues regarding the misuse and misconduct of not only the death penalty, but many of the schemes of punishment. Indeed, what I have not heard discussed today is the fact that the issues of Batson violation or jury selection, which is inappropriate based on racial concerns, is not out of the picture for the death penalty, but in fact is indeed very much so at the forefront of it. And many convictions.
Mr. Figler, I'm going to go ahead and stop you right now. Your testimony right now is not added information on the bill. Right now, we are taking neutral testimony on AB 395. I would ask you to call in. This seems more like public comment on the general justice system and some of the failures that you see and that would like to highlight. So at this time, I will recategorize your comment as public comment for our record. And if I can ask you to finish up, you do have a couple more seconds in your testimony.
I appreciate that, and it's a nuanced distinction, and I appreciate your comments on that, Assemblywoman. Ultimately, I think that the death penalty and many of the systems of punishment are untenable as they exist. We talk in this bill about the default of life without the possibility of parole, which also has issues not addressed by this particular bill, and also the misuse of the death penalty, which has not been discussed, which is also at the heart of this bill. For instance, when the district attorney seeks it against individuals who are mentally challenged.
You are at 2 minutes, Mr. Figler. You are at 2 minutes, Mr. Figler, so I will be stopping the testimony.
No, I appreciate that. I'm just saying by default, we do need to address
Broadcast
the death penalty.
services, if we can go to our next caller in neutral.
For callers wishing to provide testimony in neutral on Assembly Bill 395, please press star 9 now to take your place in the queue. Caller with the last three digits of 490. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Cyrus Hojati, Cyrus Hojjaty. I just want to give general comments about death penalty. Is it okay to do that now? Or
you know what, Mr. Cyrus, can I have you call back in public comment?
I appreciate it. Sorry about that.
No problem. You could go ahead and hang on the line and we'll get public comment shortly. Broadcast services, if we can go to our next caller, neutral. Again, I would remind all the callers on the line, this is the time for neutral testimony. If you have general comments about our justice system, I would direct you to wait until public comment.
Thank you, Madam Vice Chair. The public line is open and working. However, there are no further callers for neutral at this time.
Thank you. And with that, I am going to open it back up to, I know that we had some pretty substantial testimony in opposition by the 4 district attorneys that were on the Zoom. I know that they are there. Hopefully they have also designated one person to be the person to answer any questions, or at least limit it to one person answering each question. I do have some questions in the queue, and I will start with Assemblywoman Hardy.
Thank you, Madam Vice Chair. And first, I just wanted to say to all those families that have called in and shared their stories for our benefit. I'm sure that each time you have to talk about what happened to your loved one and friends, it's very difficult. And so my heart goes out to you, and thank you for sharing your stories. So my questions to the DAs, I've just been kind of writing down what was said and, you know, trying to understand how murder cases in general are handled. So I know that all of you use words such as heinous, brutal, egregious, worst of the worst, and when you are considering whether to have the option of the death penalty. So, and you also said the evidence of guilt is overwhelming, and that the death penalty is used sparingly. So is that correct? Do I understand that correctly? Like the aggravating circumstances and such as all these cases that we just heard, that's what goes into consideration when you decide if you're going to ask for the death penalty?
Well, Assemblywoman, if I may, I'll try and answer your question. This is Steve Wolfson, the Clark County District Attorney. Yes, we conscientiously look at every case on an individual basis. And we look at the circumstances surrounding the offense, the nature of the offense, the degree of brutality or senselessness, if you will. We look at a person's criminal history. We look at whether there is one victim or multiple victims. So we look at a myriad of issues when determining whether or not to seek the death penalty. And here in Las Vegas, Clark County, it is the minority of cases that we seek the death penalty, a fraction, if you will. I think I said in my opening remarks that last year we only filed the notice of intent on 2 cases. And the previous years were numbers around 8 or 10 of the many, many murder cases which we do consider. So it is a minority of cases that we consider for the death penalty, and we are very, very conscientious in the criteria we use in making that decision. I hope I've answered your question.
Yes, thank you. And that was, I was going to ask, I thought I heard you say in 2020 only 2 of those notices were filed, so you did cover that. And if I could just have another follow-up.
Go ahead, Assemblywoman Hardy.
Thank you. And also, I believe you mentioned that when you are considering charging or that penalty, you do discuss with the victim's family how they feel about that. Is that correct?
Yes, I'll follow up, if you will, Assemblywoman. Thank you for the question. It is very common for us to meet with the family members of the victims. And we do that in many cases, not just murder cases, but in particular murder cases and cases involving the death of a loved one, because we want their input. And I would say that in the majority of cases, the family members of murder victims want us to seek the death penalty. Again, we don't impose the death penalty, but if we decide in that small fraction of cases that it's a worthwhile option, we ask the jury to consider it. But yes, we meet with victims' families on a regular basis, especially in capital cases.
Thank you. I appreciate that. And, you know, these are big decisions, and appreciate the care and all that goes into this. And then my final comment, which I think you covered again before I got to it, was the prosecutors aren't imposing these. It is just a notice of an option that's sent to the jury. Do I understand that?
That's exactly right, Assemblywoman. Steve Wolfson again. When we decide to seek the death penalty, it is one of the options given to a jury. The ultimate decision, whether to impose the death penalty or life with or without the possibility of parole, is absolutely up to the jury.
Thank you, Mr. Wolfson, and thank you, Madam Vice Chair, for the questions.
No problem, Assemblywoman Hardy. Next, I'm going to go to Assemblywoman Summers Armstrong.
Thank you, Vice Chair Wynn, and thank you just to the families who had the courage to call in and speak their truth today. I want you to know that I hear you and my heart is breaking for you. And I am so sad for your losses. And I just have a question for the DA. If you are in communication with families about the option of the death penalty as an option for punishment, have you ever filed death penalty charges in opposition to the wishes of the family?
Is that question directed at myself or another elected Madam Legislator?
District Attorney Steve Wilson.
Okay. I think it would be rare, it would be the exception, that if the family was feeling so strongly that we not file the death penalty, I think generally we would honor that. Because we have to think about, if we file the notice of intent to seek the death penalty and the accused person is found guilty, and we go to a penalty hearing, that the family members would express the same feeling to a jury, that they don't wish the jury to return a verdict of death. And that would make it more likely that the jury would return a verdict of something less than death. So I think that it would be the exception rather than the rule that we would file the notice when the family members explicitly ask us not to.
Madam Chair, if I may follow up, please.
Please go ahead.
So specifically, District Attorney Steve Wolfson, have you, since you have been in office, in your office, or any of your district attorneys who you employ, filed death penalty charges in a case when the family said they did not want it?
Madam Assemblywoman, I've been the district attorney now a little over 9 years, and we've filed notices perhaps 50, 60, 70, 80 times in the 9 years. I believe we probably have filed notices when the families wished us not to. But the family input is just that, it's input. It doesn't control our decision, because our ethical obligation, our moral obligation, is to seek justice in a particular case. And if we have a case,
Mr. Wilson, if I might just ask another question, Madam Chair.
You know what? If we can let Mr. Wolfson finish his answer on that, and then you'll be able to follow up.
Thank you, ma'am.
and thank you, Madam Vice Chair. I think the point I'm trying to make is that the victim's input is important and we consider it strongly, but there are some cases, I have to think, in going back 9 years, where there were multiple victims and the perpetrator's criminal history was such that it was so violent that we believe that justice required us to give that option to the jury rather than fall on the request of the victims' families. These are tough decisions. And when the families don't want a particular penalty, it's hard to go against what they want. But justice is what controls our decision. And if it's a particularly violent, heinous, multiple defendant, bad criminal history perpetrator, yes, I'm not going to say we haven't done what you've suggested.
Ms. Assemblywoman Summers Armstrong, do you have any follow-up to that?
Yes, Madam Chair, I do. So what we are hearing from you, District Attorney Steve Wilson, is that even if a family who has experienced this has asked you not to, it's your choice and your office's choice at the end of the day to determine what sentence you want to seek, even if this sentence is contrary to what the family wants, disregards their pain, disregards their interest. And I'm concerned with that because it seems contradictory to what we heard earlier today. And it's very concerning to me.
May I respond quickly, Madam Assemblywoman?
Yes, briefly, because I do want to be able to have District Attorney Hicks as well as Ingram be able to respond if they have any comment on this as well.
Sure, real quickly, Steve Wolfson again. My ethical obligation is to seek justice, and a victim's family's opinion is certainly important, but I also have the community and the other members of my community to consider. And justice is a broad term, but in seeking justice, there are many, many factors that go into a decision in what kind of prosecution to bring and what kind of penalty to seek.
Thank you, Mr. Wilson. Mr. Hicks, do you have any further comment on whether or not to answer Assemblywoman Summers Armstrong? I just want to make sure that we're encapsulating the entire state as a part of our conversation.
Thank you. This is Chris Hicks. I appreciate you asking. I don't have anything to add. Our process is generally similar to Mr. Wilson's. We always consider what the victims' families have to say, and in every death penalty case I've been involved in my career, they have been in support of it. I would also add one thing to consideration as well is when we are contemplating whether or not we're going to seek the death penalty, we also accept mitigation evidence from the defense that might help us better understand who their client is and whether or not acts occurred in their life that might mitigate against us seeking the death penalty. That is also something we consider.
Thank you, Mr. Hicks. Mr. Ingram, do you have any further comments on this as well?
Thank you, Madam Vice Chair. Tyler Ingram, Elko County DA. I agree with everything that Steve Wolfson and Mr. Hicks said. I just wanted to address the question in that in the 10 cases that I spoke about earlier in my testimony, I have never gone against the wishes of the victim.
Thank you for that. Short and to the point, not like a lawyer. I have another question from Assemblywoman Gonzalez. Ms. Gonzalez, we can't hear you.
Can you hear me now?
We can hear you now. Go ahead with your question.
Thank you so much, Vice Chair Nguyen. Assemblywoman Cecilia Gonzalez, District 16 for the record. I just have two really quick questions, but I also want to definitely reiterate what my colleague stated, that I am very sorry for the loss of the families and commend the courage that they had to speak up in today's hearing. I wanted to know, number one, can someone who opposes the death penalty sit on a death penalty case?
Why don't we go to Ms. Weckerly? Can you answer that question?
Sure. Good morning. There are exclusions that can be made in jury selection by law. If someone cannot consider the death penalty under any circumstances, they are not qualified to sit on a capital jury. And the sort of the opposite side of that is if someone believes that the death penalty is the appropriate punishment in every case of first-degree murder and will not consider the other sentences or evidence in mitigation that's presented by the defense side in making that determination, they're not qualified to sit on the jury as well. As I'm sure you probably suspect, we want jurors who are open-minded and will listen to everything that's presented before making a decision like that, because I'm sure it's not lost on you, it's a weighty decision, that they're going to carry the rest of their lives.
And I believe Assemblywoman Gonzalez, you had another question. Is that correct?
Yes, thank you so much. I just have a lot of concerns when we talk about juries and how we select them, but I recognize that that is definitely not a conversation for today's hearing. Again, Assemblywoman Gonzalez for the record, District 16. So I'm also curious to know, how many cases has the state sought the death penalty, and how many times did the jury come back with death, and then how many times of those were cases overturned?
And Assemblywoman Gonzalez, is that directed at any one of the particular district attorneys?
No, anyone can answer.
Trying to avoid the roundtable, but why don't we start with District Attorney Hicks? And if you don't have that information offhand, I understand that. If you could try to obtain that information and get it to our committee members, I'm sure that would be appreciated as well.
Thank you, Vice Chair. This is Chris Hicks. I don't have that information at my fingertips. I could only speak to Washoe County, but I do believe we can get that to the committee.
District Attorney Ingram, do you have that same information, or would you need to obtain it as well?
Thank you, Madam Vice Chair. Tyler Ingram, Elko County. I can only speak to Elko County. I believe that was one case, and it was not a ruling of innocence, if I remember correctly. That was far before my time here.
And either Ms. Weckerly or Mr. Wolfson, do you have that information as well?
Thank you, Madam Chair. I don't have the particular numbers right now. I could certainly provide them, but I can tell you that, as I stated before, in my more than 9 years as the district attorney, I've sought the death penalty 50% less than my predecessor did for the many years he was the DA. And then again, last year, only in 2 cases. Now, the number that the jury actually returned, I don't have that. It's, again, a fraction of those where we file the notice, but I can certainly provide this committee with the actual numbers in the near future.
And, probably, I don't know if any of the, Chair Yeager, do you know if any of your presenters may have collected that information as well?
Thank you, Vice Chair Nguyen. Steve Yeager for the record. I believe Mr. Coffey might have those numbers. He's been tracking this for quite some time.
Mr. Coffey, if I can have you unmute and turn on your camera if you're able to answer that question.
Yeah, absolutely. And I provided exhibits for the committee, and I hope Ms. Weckerly and Mr. Wilson, feel free to check my numbers. I can provide case numbers for everything I'm about to say. Over the past decade, since January 1st of 2010, there have been 150 death cases that resolved, 37 verdicts, resulting in 16 impositions of the death penalty. So I think that answers the question for Clark County anyway. When it goes to trial, juries are about 60% likely to return a verdict of less than death. And only about a third go to trial, a little less. Actually, about a quarter go to trial.
I actually have a follow-up. Have any of those, I'm sorry if I missed it, did any of those, at least in your record, result in not guilty?
Yeah, Michael Simmons. I think Ms. Weckerly was the prosecutor on that. It was capital the first time around, and it was not guilty in the second trial. It was no longer capital because death penalty was off the table by the time of the second trial, which is a hung jury. But that resulted in not guilty where the state had sought the death penalty.
Thank you. And I'm just doing one more run around here. Oh, also, Mr. Coffey, if you could also provide that like written documentation that you might have for the committee members, and we can distribute that amongst everyone as well.
And Madam Chair, if I might, it should have been provided.
Oh, okay. Okay. And so I will direct members to the exhibits that were presented. 1 second. I think that's all we have. At this time, I have allotted a little over 20 minutes to some additional questions. So at this time, I will turn this back over to Chair Yeager for any brief closing remarks.
Thank you, Madam Chair. Steve Yeager, for the record. With your permission, I assure you we will be brief, but I would love to give Mr. Coffey and Ms. Hart a chance to make some very brief concluding remarks, and then I'll just have a minute or two, and if you'd allow that, please, Madam Vice Chair.
That would be fine. Go ahead, Ms. Coffey or Mr. Coffey.
Thank you. It's the hair, Madam Vice Chair. Scott Coffey here in support of AB 395. I think by now the problems are apparent with Nevada's death penalty system. Mr. Valoria talked about prosecutors and how that motivations can enter the judgment as to whether or not to seek a death sentence. I think that's definitely true. I need to give credit to Mr. Wolfson. I consider Mr. Wolfson a friend, and he does listen to us present mitigation, which is a nice change from his predecessor. That said, I don't believe that the filings are down. I don't think 62 pending cases is in any way, shape, or form sparing and judicious use of the death penalty. That is the number one ranking of pending capital cases by capita in the country out of 3,000 counties. I understand last year we only filed 2 capital cases, but in retrospect, I believe that has as much to do with COVID as anything else. This year we've already filed 3. The average under Mr. Wilson's administration has been about 10 a year, give or take, with highs in 2017 when they filed 16. So I'm fairly aware of how many they're filing. The vast majority of these cases, despite what we've talked about, the need for the death penalty with multiple homicides, are not multiple homicides. I've heard that some cases simply require the death penalty, and I understand that so long as the death penalty is on the books. I've heard that it's necessary for graduated punishment, but the truth is graduated punishment in this instance is an absolute myth, because we've sent 161 men to death row and we've executed 1 involuntarily. So whatever label we put on these cases, they are in effect life without parole. There's nothing we can do about that. I agree with the callers, and my heart goes out to all the callers who have been victims, and I don't want to minimize anything that might happen. But the truth is, if we have promised these people that the justice of the death penalty is coming, we have made a false promise, because we are not carrying out the death penalty. I've heard discussions that we need to fix the death penalty, but the truth is we've tinkered with it for 40 years, and we've not been able to fix anything. I thought it was interesting that there was a comment concerning the death chamber, that we haven't used it. I had a friend that once told me, no matter how far you've went down the wrong road, it's always time to turn back. And I think that's the case with the death penalty and 30 years of tinkering. We talked about juries, and the juries do return death penalty verdicts, and the need to respect their verdict. But the fact is these juries are somewhat tilted. If you don't believe in the death penalty, you cannot sit on a jury, which disqualifies nearly 50% of our jury pool. In addition, even the people that are predisposed to the death penalty are returning death in less than half the cases. So on top of everything else, as far as juries go, the juries are uninformed. Juries are instructed in a capital case that they are to anticipate that capital punishment will be carried out, that the person will be executed. And that is simply not true. They don't have the information that this committee has. I don't want to take anything away from any of the victims. I understand the desire for the death penalty for these people. But the fact of the matter is we are not executing people in Nevada, and we haven't for a long time. I heard a caller mention that we should speed up the appeals process. I am, again, familiar with that process, but it hasn't happened. When the federal government tried to speed up with the AEDPA in 1996, it didn't speed anything up. And we've not sped anything up. California's Truth in Sentencing Death Penalty Speed Up Act, whatever you'd like to call it, didn't speed much up either. In closing, I think the death penalty is broken. It's been broken for a long time. It creates false promises for victims, and I urge this committee to pass AB 395. I think it's good for Nevada, and I think it reflects the reality of what we've got. Thank you.
Thank you, Mr. Coffey. If we can go next to Ms. Hart.
Thank you, Nancy Hart, for the record. Now is the right time to abolish capital punishment in our state. It's immoral, ineffective, unfair, wasteful, and inhumane. I'm sure that some of you on the committee have long held a belief that the death penalty was an appropriate punishment for certain severe murders. I invite you to consider that you don't necessarily need to change your belief in the concept of the death penalty in order to support this bill and to support the conclusion that the death penalty as administered, as applied in our state is, as you've heard, broken, too broken to be fixed. There is no better time to end the dysfunctional, ineffective, wasteful, and inhumane punishment. And I urge you to pass AB 395. Thank you.
Thank you. And finally, last words to Chair Yeager.
Thank you so much, Madam Vice Chair, members of the committee. And first want to express that I appreciate those who have weighed in on this and have shared their lived experiences with us as a committee. That's what this process is all about, and I really appreciate it. I have an email that I just wanted to share a part of it. It's from Jackie Crawford, who spent 40 years in our Nevada correctional system, including the former director of corrections for the state of Nevada. She could not be here today, but I'm just going to read one quote that she wanted me to convey. She did testify in 2017 on a similar measure. She supports the bill. She said, "In my professional opinion, the death penalty only deters the person who is put to death. I believe that sentence of life without carries a stronger message. The death chamber is both expensive and can have a negative impact on the overall culture of the specific institution, its staff, and its inmate population. It is indeed time for Nevada to shed the old mentality of an eye for an eye in favor of a new fact-based way of looking at this issue, to hold offenders accountable with a sentence of life without the possibility of parole. The government ought not to be in the business of killing, bringing yet more unnecessary pain to a world that already has plenty of pain. It is my sincere hope that Nevada chooses to no longer tinker with the machinery of death." And I will end with a quote from Dr. Martin Luther King Jr. "Returning violence for violence multiplies violence, adding deeper darkness to a night already devoid of stars." And I just want to repeat that one more time. Returning violence for violence multiplies violence, adding deeper darkness to a night already devoid of stars. I thank you so much for your time, Madam Vice Chair, members of the committee. I urge your support and passage of Assembly Bill 395.
Thank you. And thank you to all the committee members. This wasn't the easiest hearing to hear, so I appreciate everyone's compassion and patience as we move through this bill. So at this time, I will close the testimony and the hearing on Assembly Bill 395 and turn it back over to Chair Yeager.
Thank you so much, Madam Vice Chair. And I will note, we do have some of our members who need to leave. If you need to leave, you are excused from the meeting, and I think we will still have a quorum to be able to get through the last part of our agenda. So thank you for your patience this morning. That takes us to public comment, which is the last item on our agenda. So just by way of reminder, we have 30 minutes for public comment. Public commenters will have 2 minutes on the public comment line. Public comments have time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee, so it is not a time to offer your views on the bill that we just heard. BPS, could we go to the public comment line and see if there's anybody there who'd like to give public comment this morning?
Thank you, Chair. For callers wishing to provide public comment, please press star 9 now to take your place in the queue. We will go with caller with the last 3 digits of 490. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Hello, Cyrus Hojjati, Cyrus, Hojjaty. I just want to talk about death penalty in general. I think my biggest issue is that I think that it could possibly mean that somebody could be falsely accused. And I just think that that's probably one of the reasons why it's a good idea to just get rid of it. I think sometimes people, regardless of what crime that they've committed, deserve second chances. I think this mass incarceration is not really helping the people who deserve punishment. I think that, yeah, while punishment is reasonable, I think people should have rehab and some sort of counseling to improve themselves. And as far as I know, however, one of the consequences of abolishing the death penalty, this could backfire. I mean, if you recall what happened in Charleston with Dylan Roof about 5-6 years ago, if we were to abolish the death penalty, and let's say if there's severe budget cuts and these people go free, God forbid another incident could happen like that again. So, but then again, is mass incarceration going to help these perpetrators? And the answer is not really. So I think we need to really look at mass incarceration as realizing that perhaps that's also another part of the question. And just in general, I was hoping that when are you guys going to have like town halls? Because I really would like you guys to have like town halls. We can, meet face to face, or we can just perhaps have visual conferences where people can just call in. We can see each other via video. I would like to see us to have a more in touch form of government. People are really represented in a more fashion, and I just don't really see how this process is really working out. So, other than
Mr.
that,
Hojjati, could you
thank you.
Please wrap up?
Yeah,
I think that was the end.
Thank you so much.
Okay.
You don't want to hear me?
Thank you so much.
You don't want to hear me? Okay.
Thank you so much, Mr. Hojjati. You just got your 2 minutes in there. We appreciate it. BPS, is there anybody else on the public comment line?
For callers wishing to provide public comment, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 556, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE GRANT. My brother Thomas Purdy was murdered by Reno police and Washoe County Sheriff's Office. Like George Floyd, he was asphyxiated to death. I've been watching the trial of the officer that murdered Mr. Floyd, and I have to say it just brings back the trauma of watching my brother be asphyxiated to death while the officers thought enough to get a handheld video camera. They didn't think enough to call an ambulance for a man that was literally laying. The ground was literally soaking wet with his sweat when they lifted him up off the ground as he was begging for his life. Please don't do this, guys. Please don't do this. My heart goes out to all the families who testified today. It was really powerful testimony. My brother's murderers will not face any consequence because they wear a badge. My family is still victims, just as those families are. Even though our loved one's killer wears a badge, they need to have consequences. If anything, we need to hold those wearing a badge at a higher standard. until we have laws that actually punish law enforcement who kill people unjustifiably, though I don't think the state of Nevada has ever ruled a police murder of a community member unjustified. We need some law changes. Perhaps if these officers know they're going to go to jail, if they kill somebody, they'll think twice about it. Today marks 3 years since 21-year-old Nicholas Sedano was shot and killed by Reno police. He was unarmed. Please keep his family in your thoughts today. Please support bills that promote transparency and accountability. Thank you.
Thank you for your public comment, Ms. Grant. BPS, if there are additional callers, let's take the next one, please.
Caller with the last 3 digits of 106. Please slowly state and spell your name for the record. You have 2 minutes. It may begin.
Hi, my name is Emily Driscoll, Emilydriscoll. Assembly Rep Wynn, you are my representative, and I am also in Senate District 3. I just wanted to call about the restriction of testimony in support of AB 395. I was waiting in the queue to be called, and our testimony was cut off early. It was especially disappointing to be have support testimony cut off early when the opposition, all of the DAs, got ample time to present, and then after they got time to present, they got to answer almost every single question that was asked by the Judiciary Committee. So I think that, and from my position, this seems like really a restriction of our civic rights. We should have enough time to testify. We should have, the fair opportunity to participate. Just because maybe our position isn't as favorable as the positions of our elected officials, doesn't mean that our testimony doesn't matter. I yield my time.
Thank you for your public comment, Ms. Driscoll. I will note, I think Vice Chair Wynn noted at the beginning that she would give equal time to support and opposition, and I think she did that. I think it was 40 minutes for support, maybe 42 or 43 for opposition. So at least from my standpoint, I think it was a fair hearing, and certainly appreciate that not everybody was able to testify. And if you were not able to testify, we would ask you to submit those comments in writing. Unfortunately, we only have 120 days to get our business done here, and we have to move the process along. But thank you for those comments. BPS, are there additional callers for public comment?
Chair, the public line is open and working. However, there are no further callers for public comment at this time.
Thank you so much, BPS, for helping us to manage the phone lines today. Extra duty, there were a lot of callers, so we appreciate it. I'll close public comment. I know we've lost a few of our members that had another obligation, but anything from members of the committee who are still with us this morning? And I was assuming no, because you're probably all ready to be released and get on with your day. So I'll just say quickly that we do have Judiciary Committee tomorrow morning at 8 o'clock. We have 3 bills on the agenda, and we also have a work session. So be on the lookout for the work session document that should come to you sometime this afternoon. And of course, please feel free to reach out to me if you have questions or concerns about anything on the work session. My intent is to do the work session first tomorrow morning and then take the bills. And then, of course, we have an agenda out for Friday. We'll be meeting at 8 a.m. That's enough for me. Thank you all for your hard work and attention this morning. I will see you back here tomorrow morning at 8 a.m. This meeting is adjourned.